Sorry, there was some technical error in the cause list.
My lord, I may be
Yeah.
permitted to bring on record an affidavit in reply. Obliged.
In item?
In item number 36, revised. Supplementary.
Or the new 36?
New 36, 31.
Earlier?
31.
Okay.
Obliged, man.
May please, your lordship. Item number 13 and 14. This matter may be taken up at 2 p.m., my lord. I did some instruction, my lord. Long pending cases, my lord. At 2 p.m., my lord.
That recruitment of junior engineer.
Obliged, my lord.
2 hours of period. Inform the petitioner.
But I'm the petitioner, my lord.
Oh, we'll take it up when the matter reaches. Now again. Why, without making any information, you are here?
I mean, come, my lord. Now I'm going,
No. Let them come. We'll then fix it up.
my lord.
Yes.
Item number 20 of the earlier list, my lord.
20.
20, my lord.
Oh.
These are, my lord, matters relating to this grade 4 employees in health department. We are relying upon a division bench matter in
Well,
which lordship had appeared, my lord.
Item number 20. Registry to list this matter again. List this matter before any other bench without. I think that appeal is heard finally.
Appeal is already heard, my lord, and decided in our favor. We are seeking a similar relief.
I think I should not be. Yes. Item number 20. Next.
Lordship,
Yes, madam.
I beg to mention item number 22.
Why?
I am appearing on behalf of PS Locker. Due to his personal difficulties, he is not coming today. Matter
A
may
prayer
be
is made on behalf of Mr. P.S. Laukar, Lanat CGC.
be fixed after beautification.
For an adjournment in the matter on account of personal inconvenience. Registry to list this matter again after 3 weeks on a date 2 weeks.
May I pray for a date?
Motion.
Will you be here on that day?
Supplementary motion.
Motion ko na di, sir.
3 weeks of
Immediately
schedule.
after the.
Immediately after the UD. Honey,
Oh,
madam, your item number 22. Sure.
no. List con খেলমেলি হয়েছে।
No.
Please come
22, Mr. Doctor, there was some technical error in the numbering. I think you're that 20, you are in for which matter?
This is
WPC number, give me
75, 2026.
1575.
That
Is item number 27 now.
27.
It is that election matter.
Fine.
No, 27 in the supplementary list. Right now, no problem.
May I please, your lordship.
Lordship, I'm checking for listing of an IA for order correction, your lordship. For tomorrow,
Today at 2 p.m.
lordship.
Did you?
Please, your lordship.
About tomorrow.
Your lordship, I beg to mention item number 16, your lordship. Your lordship, my senior is out of station. He'll be back tonight, your lordship. My senior is out of station, your lordship, and this matter is to be done. There has some technical issues which he must do.
You are claiming pay parity with boiler assistance. You could have given me a list yesterday. I would not have gone through the.
Already have.
You have supplied.
Yes, your lordship.
Oh, then I missed out. Okay. A prayer is made on behalf of Mr. B.D. Lanat Senior Counsel for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the. Have you informed the other side?
Yes, your lordship.
Not objected to by the Lanat Council for the respondents. Accordingly, registry to list this matter again when?
24th.
Came in the month of April, lordship.
On 1/4/2026. Along with WPC number 2536/2024. Or WPC duta ekalage mairibi. Ba itu belek ke mari tat lagai dibi. List along with so and so. Yes.
May I please, your lordship. Lordship, I beg to mention item number 12, my lord, here. Item number 12 of the earlier list, my lord, main list.
Till 20 there is no
My lord.
problem.
Item number 12, my lord, the petitioner expired, my lord, and
When did he retire? Originally?
originally he
When the
retired.
order was passed, penalty order was passed,
He-
was he in service?
No. At that time he retired, my lord.
How can a a penalty under rule 7 be passed then?
Thereafter, his pension, from the benefits, service benefits, the amount was deducted as a penalty, my lord. That is the thing.
You file a substitution.
Substitution, madam.
Uh,
R.H. Chaudhary.
But see, the issue here is that penalty was issued under Rule 7.
Rule 7.
Rule 7 is permissible till you are in service.
Service, madam.
Once you have gone out of service, it'll Rule 21 of the pension rules will take over. There is no, you have not developed your case in that line. Keep it in mind.
Lordship.
Your name?
R.H. Chaudhary, lordship.
R.H. Chaudhary, Learned Counsel for the petitioner. Submits that the petitioner had during the pendency of the present proceeding passed on,
On 2020, your lordship.
passed on
exactly, I don't
in the year
We are not aware of it.
2020. Accordingly, he prays that he be granted 2 weeks' time to file a application for substitution of the petitioner with his legal heirs. Also, prayer accepted, registry to list this matter after 2 weeks.
I'm deeply obliged, madam. I agree.
Please, Your Lordship. Madam, instruction was sought from the,
Not instruction. You have already been evicted.
my house is demolished, Lordship, but the proposed land has not been constructed yet, Lordship.
That will take time. Mr. H. Sharma, Learned, additional senior government advocate, submits that the matter be taken up on when?
2 weeks, Lordship.
Actually, why you went ahead?
No, Lordship, the letter, we have written the letter on 17th, today is 19th. So, Lordship, after 2 weeks or 3
No.
weeks.
On 30/3/2026 to facilitate completion of instructions by him. Also, Mr. Sharma, on the next date of listing, shall place on record the stand of the respondents with regard to the claims made by the petitioner in the present writ petition. Interim order passed earlier to continue till the next date.
Lordship, fixed it on 30.
30.
Lordship.
27 to Q. Mr. Just a moment, there is another matter in between, 27. Because of the listing problem, there is some. 22 to
May it please, Lordship. My lord, your petitioner contested the last election way back in 2021. And my lord, he lost. And again, there was a by-election in the same year. He contested, again he lost. Now, my lord, during campaigning period, my lord, he sustained very much injuries in his left leg, which was, the surgery was conducted previously. Now, as a result, my lord, he had to shift to Delhi and admitted in the Max Hospital, where, my lord, the left leg amputation was there. And because of all that, my lord, he could not lodge the expenses of the election expenses in time. Now, your lordship will find curiously at page 103, my lord. I'll take your lordship directly to that. This is the disqualification order, my lord, which I came to know from my well-wishers, because I was at that relevant time. Your lordship kindly see.
Mr. Dotto,
My lord.
this order was issued on 24/1/2024.
Right.
And this is after the notices were issued to you, which were received by your family members. There was no response made.
The shoppers notice, my lord, which they are saying in this letter, your lordship will find. It was never given to me, my lord.
Okay.
We did not receive it.
Then it seems that you made a representation.
Yes,
Then they responded by 105,
for filing.
saying that you file an application appeal under section 11.
Yes, we
Now
filed,
you have filed the application under section 11.
my lord.
Now show me from there that you were not served a notice.
Doesn't. Doesn't. Para 7 onwards, Your Lordship, at page 112.
No, that is after the representation submission.
After the.
Before that, you have not received.
No, my lord,
It is
but-
not there.
But they are saying that in the letter dated 24 in page 103,
Hmm.
say they have served the show cause notice in terms of the conduct rules.
Hmm.
My lord,
But
rule
where is
18
that? You have not received it.
Yes,
Where is the statement in the appeal?
the statement in the appeal,
I don't find that. You are only justifying the delay.
exactly, my lord. Because your lordship will appreciate one thing.
And I found a statement here that even in the appeal, you have not given the full and complete statements of expenses.
My lord,
There
what
is some
happened?
statement in the petition.
My lord, one of my,
114. Yes.
para 8, my lord.
Hmm.
Finally, he could find the register
No,
of
the last
expenses.
3 lines, 4
The
lines.
last 4 lines.
However, in spite of best efforts, so and so, so you are still not given the complete documents.
That, your lordship kindly say, however, in spite of his best effort, the election agent could not find the voucher number so and
Mr.
so.
Doctor,
Yes,
the disqualification under 10A was subject matter of many decisions. It's a mode. It is permissible. But the protection is under section 11.
under
Now-
section 11, my lord, they can remove that.
They can remove, they can reduce, they can do whatever they want.
Yes,
Now you have preferred a appeal, be that as it may, as it is, on 3/12/2025. What have you are appearing for the election?
Election Commission.
What have you done with this appeal?
Lordship, since the documents aren't complete, Lordship, we're not able to go ahead with the appeal.
Where is your, that decision that because of the lack of documents, you are not in a position to go ahead?
Lordship, I'll produce it on the next day, Your Lordship.
Produce it on Monday.
Lordship.
my lord, nomination paper, with the
Can't help
last
it.
date is
Can't help
23rd.
it. You can't take advantage of your own latches.
Apart from that, my lord, apart from that, your lordship kindly see at page, I'll take your lordship to that.
Hmm.
Your lordship kindly come at page 35. Down below, your lordship will find the bottom. The date of disqualification 24/1/2024.
Hmm.
Now, your lordship can see again at page 103. Date of disqualification is from 24/1/2024 because they have disqualified me by order dated 24/1/2024. Now, supposing, my lord, we did not lose the expenses of election expenses.
Hmm.
In that case, my lord, it is in terms of section 78. My lord, within 30 days of the returned candidates election. From that date, my lord, they could have, that is way back in 2021. If they could have passed that order, I would not have debarred from the, my lord, contesting this election.
No, the thing is that they were waiting for your, there is no time frame prescribed in 10A for passing of that order. But the 10A procedure is that they'll have to give you a notice
Yes,
and wait for your response.
this is a mandatory, man.
Mandatory. They have done that, but the response did not come. It's not your case that no notice was issued.
No, that your lordship will find at page 116, para 11, my lord,
116.
paragraph 11. That your appellant states that as per the section 11 of the RP Act 51, the election commission may, for reasons to be recorded, remove any disqualification under the chapter, reduce the period.
What is that 89.5? Conduct
80
of election.
89.5, this is a conduct rule, my lord. Here, we have annexed it at page, the last page, your lordship will find. 126. 89 subsection 5, my lord, where the election commission decides that a contesting candidate has failed to lodge his account.
But that is further qualified by page 104,
Yes.
first paragraph. The notice was served through your father. And any statement in the writ petition that this is incorrect.
No, we have stated, my lord, we have never received.
No, 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 that is different, but there is now a order that it was served through your father. You will have to deal with that
Yes,
because this is a election case. The technicalities will follow.
yes, yes.
So you say 89.5 notice was not given. They say that it was served on you through the district election officer Baska on a date is also given, 8/3/22. Maybe erroneous, but where is your projection that that is erroneous? Merely saying 89.5 notice has not come will not do here.
Again. No, the only thing my instruction is that we never received it, therefore we have made a
Okay,
denial.
let us
in
see your statement in the writ petition
Yes.
to that effect.
that. And there's the petition, para 7 at page 9, my lord. Specifically, I've stated in page 13, my lord. In para 11,
Para 11.
yes.
Again, you have not dealt with that statement.
That the query your lordship is posing.
That you have not dealt with.
That, of course, but then ultimately, my lord, it is their burden when they have said
Yeah,
so.
that will have it. Don't worry.
Lord, can I propose one thing, my lord?
Hmm.
If your lordships allow him to file his nomination paper, subject to the condition whatever happened in this rate petition.
This is a debarment notice. Until and unless we decide either way, we will not permit it. And the delay is on your account. Be that genuine reason maybe, but on your account.
My lord, if they can provide that information tomorrow, your lordship can take it tomorrow.
Madam,
Lordship,
get your instructions.
Lordship,
We'll have it on Monday.
Lordship,
First item.
Lordship.
Thank you.
If I may point out one thing, Your Lordship. Lordship, as regards the service of the show cause notice, Lordship, in page 7, towards the end of the paragraph, Lordship, the petitioner admittedly was in Delhi.
So no, I got it. It was that is a
So it
different
was
thing.
served upon his.
If it was served on his father, that is enough.
Lordship,
You can't go chasing a candidate where he is to find out. But if it is served on his father,
Lordship.
if you can establish that, the case will fall through. Heard Mr. S. Dr. Learned Senior Counsel.
My lord, one thing, my lord, it can be fixed tomorrow because Monday is the last date for filing nomination.
Okay, tomorrow, 2 p.m.
Just on the point of service of the show cause.
Notice and service of show cause notice under 89.5
Lordship,
and also your what you have done with this 3/12/2025, why you have not proceeded with that. So on 3 months now.
Lordship.
And if you have kept it pending, you must have recorded some reasons for that.
Lordship.
We want that reasons for that.
Lordship.
Also assisted by Ms. R. Shekhar, Learned Counsel for the petitioner. Also heard Ms. You now write Borua.
Khattak, Your Lordship.
P.
S. Katik.
S. Kotuk, Learned Counsel, Learned Standing Counsel, Election Commission of India. Ms. Kotoki, by Ms. Kotoki shall receive instructions from the respondents represented by her as to when the show cause notice under section 89(5) of the conduct, under rule 89 bracketed 5 of the conduct of election rules 1961 was served upon the petitioner and or his family members. Ms. Kotoki shall also apprise this court as to the steps taken by the Election Commission after the receipt of the appeal appeal preferred by the petitioner under section 11 on 3/12/2025, along with the date on which such appeal was received by the Election Commission. Registry to list this matter again tomorrow, again on holiday 20 at 2 p.m.
Published.
Because, madam, it's a technical issue. If
Lordship.
there is one lapse on your part, the whole action will go.
Lordship. Obliged.
Yes, Mr. Abhinav.
My lord, may I pleases your lordship.
Hmm.
My lord, the matter relates to, my lord. My lordship is well aware, my lord, that the government of Assam, my lord, is now carrying out various eviction drives and eviction exercises also been carried out. And my lord, this is also an area, my lord, wherein the forest department has claimed that we have enforced upon, my lord, certain forest land or the forest areas. That is their contention, and basing on that, my lord, they have initiated the exercise in this petitioner's area in the month of September 2025, my lord. A first notice had been issued, my lord. That notice had been assailed before my lordships, my lord, and that my lordships, though not interfered with the notice, my lord, has extended the time limit for our vacation from 7 to 14 days, my lord.
15 days.
15 days, sorry, my lord. And thereafter, we again approached before the Honorable Division Bench. The Honorable Division Bench has, though, my lord, has not said, interfered with the learned single judge's order, my lord, has again extended a little, my lord, relief we got for another 7 days, my lord. And then that order had been assailed before the Honorable Apex Court and in an SLP. And in that SLP, my lord, a detailed guideline, my lord, basing on an affidavit filed by the state had been formulated. So if my lordships allows me to bring my lordship's kind notice to that order, my lord, which my lordships may be pleased to find, my lord, is at page 269, my lord.
Yeah.
My lord, very short order, if my lordship allows me to read over these paragraphs, my lord. So it's relevant, my lord. That's why, my lord. From page 270, I am reading, my lord. 270. May I read, my lord?
This is with regard to that forest. Then para 4 with regard to the stand of the respondent.
Respondent, my lord.
And then it also goes and says what is the condition of the forest in the state of Assam.
Exactly, my lord.
And then in paragraph 9,
My
it reiterates the importance of the forest and to make it free from human habitation, not to convert it to a human habitation.
My lord.
And then it says
My lord.
in paragraph 10,
My lord.
the third line,
My lord.
does not envisage a choice between environmental protection and the rule of law. Rather, it insists that both coexist and reinforce each other. Then the affidavits filed by the state is brought on record.
My lord.
Then you can start from page 281, para 12.
Yes, my lord. Thus, from perusal of aforesaid additional affidavit filed on behalf of the respondents, the following policy decision to remove the unauthorized occupation from the reserve forest has been taken. The respondents shall constitute a committee comprising forest officials and revenue officials. My lord, may kindly note, this both has been directed, my lord. The said committee shall issue notice to the alleged unauthorized occupants and shall give them an opportunity to adduce evidence to show that they have the right to occupy. My lord, may I kindly note this word, occupy. Occupy the land which is in their possession, my lord.
Mr. Yeah,
My lord,
for adjudication of your further arguments,
my lord,
it would be important to understand clause 2.
my lord.
The onus is on you. Onus is on you by the Supreme Court order to show
No,
that you have a right to
my lord,
occupy.
I'm not denying that, my lord.
Because
I'm not-
why I'm saying so? Because your contentions in your appeal or in the representation is
My lord.
contrary to this position.
No. I'll satisfy my lord. My lord.
Okay, then
I'll
further.
make an attempt, my lord. To occupy the land which is in their possession, the action for removal of enforcement shall be taken only if it is found that there is an enforcement in the reserve forest area. In case the notice is found to be within the revenue limits outside the notified forest area, the detail of the notices shall be sent to the revenue department. In such cases, the revenue department shall decide the future course of action. The action is being taken by the state to remove enforcement from the reserve forest areas and has nothing to do in respect of the matters which may be referred to the revenue department. If an unauthorized occupation is found in a reserve forest area, after scrutiny of the documents, a speaking order shall be passed and shall be served on the concerned person, giving him 15 days notice to vacate the unauthorized occupation, and only after expiry of the period of notice, the action shall be taken to remove the unauthorized occupants. My lord.
Now let us,
My lord.
2 and 6, subject to what you said.
My lord.
6 is if an unauthorized occupation is found in a reserve forest area.
My lord.
After scrutiny of documents, a speaking order shall be passed.
My lord.
So, Supreme Court said the committee will give you a notice. Just for my understanding, you will give your stand establishing your right to occupy the adduce evidence to show that they have the right to occupy the land which is in their possession. And then the committee will examine it. And if it is found that the occupation is within a reserve forest area, after scrutiny of the documents, they will pass a speaking order. Okay. Then
my lord.
7 may not be relevant because neither your case nor their case that it is a forest Gaon Panchayat.
No, it is our case, my lord.
Okay, then okay.
Occupation, it is a forest Gaon Panchayat, my lord. They have a
Okay.
notification, my lord.
Okay.
Occupation of a Gaon Panchayat in a forest is permissible if there is a sufficient proof as per the Jamabandi register maintained by the forest department or as provided under the Forest Rights Act.
So this
My
is
lord.
again qualified
My lord.
with the prescription that it should be there in their forest because the forest maintains a register,
My lord.
Jamabandi.
My lord.
Normal Jamabandi is by the revenue.
My lord.
But forest area, forest department maintains a Jamabandi and therein they include the names of persons who are permitted to reside inside the forest area, forming a forest panchayat or are permitted to reside there in terms of that schedule
Forest
occupation
Rights
say
Act
of
2006, my lord.
2006.
My lord.
These are the two, basically what the Supreme
My
Court. Okay.
Then, my lord, in our opinion, the course of action to be adopted by the state government while removing the enforcement from the reserve forest contain sufficient procedural safeguards. The process sought to be adopted by the state government for removal of enforcement conforms to the principle of fairness, reasonableness, and due process. The learned Solicitor General has assured us that the mechanism evolved by the state shall be complied with objectively and with fairness while taking action for removal of unauthorized occupations in the reserve forest. The parties are directed to maintain the status quo in respect of the land in occupation of the appellant or writ petitioner till the speaking order is passed and till expiry of notice period of 15 days. All contentions, my lord may kindly note, all contentions are kept open to be agitated before the committee. It is clarified that this court has not expressed any opinion on merit of the claim of the parties as the same has to be examined by the committee. So this is a Milord, Milord, had there been an adjudication on merit, then Milord, we could not have come before my lordships today, Milord. So as the merit has not been decided, Milord, now it is before the committee, and as the committee has not decided the merit, that's why, Milord, we are now before my lordships, Milord. Accordingly, so and so, Milord.
Mr.
My lord.
Bhavia,
My lord,
what is your understanding of this line?
my lord.
All contentions are kept open
Yes, yes.
to be agitated before the committee. To what extent the contentions can be?
Milord, my, from my very limited knowledge.
Can the contentions also
My
be
lord, my lord.
with regard to the directions which the court has passed in the present matter from 1 to 7? 1 to 6?
No, my lord, that direction is the procedure what is required to
That's
be
what I'm
adopted.
saying. It
That
has
is
laid
my
down
lord.
a procedure.
My lord,
Whether that procedure will also be permissible to be questioned before the committee.
no. We are not questioning the procedure of the committee, my lord. My lord, may
Very constitution of the committee, whether it is permissible to be
no,
questioned.
constitution of the committee, my lord, yes, constitution of the committee, my lord, they have said that we will constitute a committee. Now, my lord, when there is a question of eviction, removal, demolition, the rights of the individuals are going to be thrashed out, my lord. In such a situation, my lord, it is the duty of the state to notify the committee that the which committee is now going to examine the, which committee is now going to, my lord, examine the issue. Just mere filing an affidavit before the Honorable Apex Court, with all respect, my lord. The Honorable Apex Court has not
You
said.
got to have gone to the Supreme Court back again
No,
and
no.
say that this committee is so vague, that
My
this
lord.
direction is so vague, that it gives unnecessary, unbridled power to the state
Lord.
to constitute committees according to their own whims and caprices. Because today, this court is bound by the order of the Supreme Court. Supreme Court only said committee. And if we go a little bit back to the affidavit file, it's a committee in the district level committed by the forest officials and the district authorities. Naturally, because there cannot be a committee other than a district level committee because the records are there.
Lord, I do not have that courage, my lord, to question the order passed by the Honorable Apex Court, my
Neither
lord.
me, I have.
Lord.
Neither this side that courage is there. Not courage. The propriety demands that I'll have to follow them.
No, we have to, my lord. We are duty bound from the ratio of law which has been fixed by the Honorable Apex Court. Now, my lord, may kindly appreciate, my lord, the manner in which they have said when we could come to know that a committee has been constituted only when the notice had been issued, my lord.
Actually,
Only when the notice had been
this
issued.
court has not,
now,
Supreme
my
Court has not said that the committee has to be notified, then objections received, a hearing, deliberation on whether the committee is proper or not. The only thing, subject to what you say,
my lord.
the only issue that is arising here is whether you are inside the forest or outside the forest.
And whether we are in a Panchayat village or not, my lord.
See,
My lord.
you had raised this plea before this court in the single bench, not considered.
My lord.
Before the division bench,
My lord.
rather rejected.
My lord.
Matter went up to the Supreme Court on the same very plea.
My lord.
The Supreme Court has not given a seal of approval to that contention of yours, but it said, okay, constitute a committee. The orders of the learned single judge and the learned division bench was substituted only with regard to the procedure, not with the materials which were there before the court.
My lord. My lord.
Now, you come to your, this is the notice.
My lord. At page 287.
Come to clause 1.
The committee shall examine this one, my lord. The committee shall examine the documents produced by you and determine whether the land in your occupation falls within the said notified forest area and that you are legally authorized to occupy the said land.
So the issue that was framed by the committee is in connivance with the direction of the Supreme Court in uh, 2, 3, 4, 1 and
Right.
2, right? Now, what is the document you have produced to show that you have a right of occupancy over the land? A Aadhaar card, a voter's ID, these are all who are the person, not who are the land through the person. I'm asking you because I want a clarification on this one. It's creating a doubt on my mind.
My lord.
These documents are your personal identity,
Individual documents.
individual identity. Now show me that these individual identity also roots you to the land wherein you are occupying.
Connecting with the land, my lord.
Land.
My lord, it is automatic, my lord.
How?
When-
Show me.
No, my lord, the question.
I was,
my lord, now-
Mr. Yeah, this is something which is troubling me. That's why I'm asking you this
Hello.
question. I, till the year 2014, was in a rented house.
My lord.
I had a Aadhaar card. I had a voter ID. I had a driving license. All with that address. But I did not have an ownership of that
Building.
house.
My lord.
So here you may have no issue on that. But where is the connecting document? Connecting you to a permissible possession of that land.
My lord, that has not to be decided by the authority because the Supreme Court says that whether I can occupy.
That's it.
Occupy.
That's it. Whether you can occupy a land
Occupy
in
a
the forest area.
particular, no, my lord, a particular, it is, my lord, the whole issue has been raised by the authority that this is a forest area. This is a forest land. It is their bounden duty to prove before the appropriate forum that this is the map, this is the notification, this is the area where we are in residing is a forest land. My lord, till date, my lord, not in any forum they could establish that this is a notification and this is a map. What they are doing, my lord, they are producing Google map. Google Maps is
Will
not.
not do.
My lord,
Will
Google
not do.
Maps is not a reliable source of evidence, my lord.
I accept that.
My lord, so therefore, my lord, it is their, as they have, my lord, is the prosecution, it is their duty to prove beyond all reasonable doubt, my lord, that this is the map, this is the notification wherein our house is residing herein. Till date, my lord, they could not produce. Now, therefore, my lord, we have said that this area is required to be
So
demarcated.
you mean to say
My lord.
that you are not within the notified area
My
of
lord,
the
my lord,
forest land?
my lord,
What is the material?
my lord.
What is the material?
No, material, my lord, may I kindly appreciate, my lord, we are residing therein from last 70 years, my lord. Till date, no.
That will not give you a right. But if you were that under that 2006 Act or rules,
Yeah, my lord.
then 3 generations,
75
75
years is
years,
required.
you get a right.
Other forest dweller benefit will.
That actually will not be here. Now, Mr. Yeah, just to clarify myself,
My lord.
why I'm asking you this question is, no forest area in the state or in the country can be declared without declaration of its boundaries. The notification must. Yesterday night, again, to satisfy myself, I've gone through the act. It has to follow that the notification that is issued is with a specified boundary. It cannot be issued without a boundary. You can't just say the area of the High Court today is declared as a forest area.
That they cannot.
It cannot.
No,
It will have to say the Ganesh Mandir on one side, the planetarium on the other side, social welfare office on the other side, and the new thing coming up. This is the area of the forest and it is notified.
My lord, I am submitting, my lord, which is very heartening to submit before my lord, my lord. These people belong to a particular community. My
Well,
lord.
I strongly oppose this, man.
Mr.
Please,
You will have your chance.
my lord, please, I am
Let him make his submissions.
not making any.
Let him make his submissions,
This is a
Mr.
submission.
He is open to make any submissions he like.
My
Yes,
lord, I am sorry, my lord, if I.
please continue with your submission.
My lord, these particular peoples, my lord, who are now, my lord, begging before my lordships, my lord, this belongs to a particular community, my lord. A very next door neighbor Lord, I am not saying that they should also be evicted or not belong to these communities, my lord, but they are not being served any notices. They are not being disturbed. Till date, they are residing there in very peacefully, my lord.
Okay.
So, my lord, this is not.
So you mean to say that you have been discriminated against?
Absolutely, my lord.
Mr. Bhia,
My lord.
as far as, I don't know what happens in the executive level or in
No.
the implementation level, as far as courts, not this court, courts as a whole,
All courts.
we function religion neutral. We have a citizen before us.
My lord.
We are not concerned whether he belongs to a particular community or the other.
My lord.
Two, this plea of yours was taken before this court before the division.
My lord.
Division bench had rejected it.
My lord.
That was not
So
set
Supreme
aside
Court.
by the Supreme Court.
My lord.
Today, if that is the question and you are a very conscious citizen, the way is always open to you to approach the division bench by way of a PIL. Highlighting, not the discrimination, that if it is a forest area, it should be free of human habitation.
That is
It's
correct.
not habitation by a particular community or another.
Particular class.
So that grievance of yours, I think I have answered. We are not concerned what your background is. You are for me a petitioner only
My lord.
and a citizen of the country.
My lord.
Nothing more, nothing less.
And I have, my lord, I have approached in that line only, my lord, that if.
So this
My lord.
plea of yours,
My
this may be a grievance. This has its own way to redress,
My lord.
not as a community, but as a matter of discrimination between two human beings.
My-
And I hope if that is true, you will take necessary steps in that connection.
My lord.
But you have not taken that step still
No,
now.
my lord, we don't want to disturb anybody. my lord. That is not our motto also.
now.
My lord.
Just to take forward from where we left off,
My lord.
come to page 471.
471.
One.
Yes, my lord.
A. Kindly
Yes,
read.
the number South Reserve Forest was duly notified by Gazette Notification Order number dated and has been continuous force ever since, and the notification has attained finality and cannot be collaterally questioned before this committee. Thus, notification also contains a vivid description of boundaries.
Now,
Now, my lord,
show me
My lord.
from your pleading that notification was issued without definition of any boundaries.
no, my lord, it is from their language. My lord, may kindly appreciate. They have said that contains a vivid description of boundaries. Thereafter, no sentence is added. They have not
It's
said that
required.
before.
You, Mr. Bhuya, just
My lord.
for my adjudicatory purpose,
My lord,
show me from your statement that this is a perverse statement.
no, my lord. From their statement, it will reflect that this is a perverse, my lord.
How?
Why I'm submitting, my lord. My lord, may kindly appreciate that the boundaries they have said, but as we within the boundary of this area, they have not said, my lord.
That you will have to go a little bit further.
That is correct, my lord.
You
Any
go a little
challenge,
bit further,
my lord, any challenge to the constitution
that
of
you forget it.
that upon
See.
detailed
Joint verification.
joint verification by the committee members, it has clearly emerged that the notice is in unauthorized occupation of the number South Reserve Forest as per the description of the Honorable Supreme Court. Opportunity to claim lawful right to occupy the land was also afforded to the noticee.
Now-
However, the noticee
Now,
is
Mr. Bhuya,
my lord.
to just understand that paragraph, come to page 470, last paragraph.
And whereas a subsequent joint field verification dated conducted by the members of the committee has conclusively established on the basis of a ground survey and reference to notified boundary records that the occupation of the noticee falls squarely within the notified limits of the number reserved forest. My lord, I am very sorry to say, my lord, that there is no any such, my lord, demarcation has been carried out. We were not at all being informed that when, where and who conducted this, my lord,
The
demarcation
Supreme
exercise.
Court never directed
My lord.
for your inclusion in the committee while
No,
making such.
No, we cannot be included in the committee, my lord.
The
At
committee
least-
has made this, now just for the purpose of my adjudication,
My lord.
what is your material to counter this in your writ petition?
That we are outside the boundary of
No.
the,
That this notified boundary limits,
my lord,
that they had conducted a joint verification
my lord.
and thereafter had come to a conclusion that this is within the boundary limit. But these materials, either they had not conducted that joint verification. Two, the joint verification, although conducted, could not have been because the boundary is this and we are here. Where is your statement to that effect?
No, no, that statement, my lord, we have said, my lord, that regarding the demarcation exercise which they have carried out, we have
Not a demarcation exercise here.
my lord.
There is no demarcation here, Mr. Bhuyan. There need not be a demarcation.
No, no,
The only thing is
my lord.
that whether there is a specified boundary, which is, we'll take judicial notice of that because no notification can be issued without specifying the boundaries. If you show that the notification of 1965 was issued without any boundary being specified, it would be a different ballgame altogether. Yesterday, I went through your writ petition to find that
No, no, that is
plea,
correct, my lord.
but that plea is now taken.
No, no, my lord, the plea which we have taken.
We are, because seeing this people being now put to the road pains us also. But as Supreme Court has said, forest and the rule of law has to go hand in hand. And the only thing, Mr. Bhuyan, you have to establish is that, see, this is the boundary and this is the area where we are living. This is beyond the boundary. Finished. Why this big exercise is required? Nothing.
My lord,
And you are not a forest panchayat area. The panchayat which you say, again, the question would be, those documents, how do you connect to the land?
yes, my lord, because there is a notification by the Department of Panchayat, my lord. We have been included basing
And
on,
that aspect has been clarified before the division bench by way of filing an affidavit. It has been clarified before the Supreme Court
my lord.
as to why these people came there, because there was involvement of departmental officials also. But these things will not give you a right to continue to occupy a forest area.
No, my lord, these things will give rights. My lord, what my limited understanding is this,
Yes.
my lord. If my lord maybe.
I want that only. I
Yes,
wanted
yes,
that from
if-
you.
If my lord allows me to bring my lordship's kind notice, my lord,
Hmm.
to few documents, my lord, starts from page. My lord, may kindly turn to page 175.
Hmm.
This is a job card.
Ah, that is again qua you.
No, no, my lord, who me,
Hmm.
but basing on who will get a job card, my lordship knows, my lord. A job card is,
I told you again,
My lord.
now we are concerned with occupation of a land in
My
the
lord.
forest area.
my lord,
You were occupying that land. You were occupying that land. No issue on that.
my lord.
Or you were occupying a land outside the boundary of the forest area. No issue. But you don't have a permissible possession of that land recognized under law. You were occupying. It is, maybe it's a revenue land or maybe it's a forest land, but you are an unauthorized occupant. That is why an eviction process is required. That is why the Supreme Court said that if you are found to be outside the boundary area, send it to the revenue department, because there was no material in the 3 stages hierarchy of courts you had approached on the last time that you had a legally permissible right to be, you were there in permissible occupation of the land. You were occupying the land. Whether you were permissibly occupying or not was a question that has to be decided by the forest or by the revenue after coming into a conclusion that you were either in forest land or in revenue land. But the question, there is no dispute on the fact that in either of these areas, you are an unauthorized occupant. The only effect would be if you are outside the forest area, the process of eviction may get further delayed because a further action has to be taken by the revenue.
My lord.
But the status as an unauthorized occupant, you have not been able to dispel.
No, my lord, for that to show that whether we are authorized or not, my lord, for that's why, my lord, these documents is relevant, my lord. These
These
documents are relevant.
documents will not show you
No,
that
my lord,
you
no,
have
and-
been, show me, Mr. Bhuya,
My lord.
that you were permitted by the revenue authorities by some order to occupy that land.
My lord, we have been permitted by the, my lord, scheme of the, my lord, may
These
kindly-
schemes are not the concluding factor.
No, my lord,
These are, you are a human being, you are there, you are a citizen. The rights, the benefits which are being given away by the government, naturally it stood attracted to you. How, why, when? These are not issues to be decided here.
No, my lord,
Here is
these are-
land.
No, my lord,
You are on government land, otherwise
my lord, that is, we are
You are
not
on government
disputing
land?
that we have.
you don't have a temporary settlement of the land.
No, no,
You don't have a patta,
no, my lord,
nothing.
no.
So you are basically an unauthorized occupant, right?
In that area, my lord,
That area.
my lord, my lord.
It may be a revenue land or it may be a forest land. But you are, let us just understand, you are an unauthorized occupant. These documents
Right.
also will not give you a permissible occupancy over the land. By being there, you were given some benefits. But these documents will not translate into you getting rooted in the land.
But my lord,
Rooted in a sense under the Assam land revenue
My lord,
regulation.
may I clarify, my lord?
Hmm.
My lord, these are the documents who has issued, my lord, these are the documents issued by the government. Government has allowed us to construct the house from the government fund under the Prime Minister's Awas Yojana. Now, my lord, if had it been a case that this is a forest land or not a panchayat area, then government in a forest, my lord, where is the question of giving
This
fund?
issue has already been gone into by the division bench.
Division bench order has been, my lord,
A procedure has
No.
been modified.
the division
What
bench.
is your take on that division bench's observation
My lord.
on this? What is the
No,
what
my
is
lord,
the material here?
With all respect to the division bench judgment, my lord, I am not, my lord, saying that the division bench has not taken care of this plea, my lord. Division bench has taken care of this plea, but when the matter went to the apex court, my lord, the honorable apex court says that the merit is required as the honorable
Okay,
apex court,
got it.
my lord. So that's why, my lord, with all respect to the division bench judgment also, my lord, though it had been, my lord, adjudicated and decided, but my lord, when the matter went to the higher forum says that the merit is open. So that's why, my lord, these merits.
Okay.
My
Now
lord,
we have to consider as per you, this committee was to consider on merits
merit, my lord.
and it has not
It
considered.
has not done, my lord.
So your merit is that the documents that the governmental authorities had issued,
Issued, my lord.
PAN card,
PAN card.
Aadhaar card, job card, house under
My
PMYJ,
lord.
and
The
extra,
the panchayat notification, my lord, notifying the area.
as Merapeni as a
My lord, may kindly take up one notification.
I've seen it. The notification declaring that two villages.
My lord, my lord,
There are two notifications.
my lord.
Page 185.
185.
186 is the relevant, 187 and 189. 190 are the relevant notifications.
My lord is more swift than me, my lord, in my petition, my lord. My lord, in page 186.
See, when
My lord.
a right of a citizen is before this
My
court also cannot be casual. It
That is
has to do its homework.
My lord,
But
No, my lord.
Mr. Yeah,
my lord.
not satisfied till now.
No, my lord, may kindly see this notification, my lord.
I've seen it.
I'm in
Merapani
exercise,
is a big area.
my lord, in exercise of the power conferred under subsection 2 of section 5 of the Assam Panchayat Act 1994.
It is
amended-
that village is still there.
That village is still there until,
And Mr. Bhuya,
my lord.
there are materials to show that in your area wherein they say that you are illegally occupying, eviction had already taken place and people there have moved out to Nagaon, Borpeta, Morigaon. That's
These are
material.
their statement, my lord. People are still residing in roads, my lord. I have, my lord, people are still residing in roads. My lord, the children are without education. Women are, my lord, finding.
Mr. Goswami,
My lord.
My lord,
15 days will be over when?
Tomorrow, my lord.
Tomorrow. Tomorrow is Eid. Do you propose to carry out the
No.
and the election model code of conduct coming in? Are you proposing to carry it out within the period when the
My instruction, madam, my discussion with the special chief secretary yesterday was that till 9th, till the date of polling, there will be no
there will
eviction.
be no eviction? That's a fair thing. Mr. Bhuya,
My lord,
you have time till 9th.
my lord.
Please do the alternative arrangements required. Alternative arrangements
My lord.
required to vacate that area. I think you have been given the most longest of the rope that can be possibly given. We will examine this issue. There is no problem in that. Let Mr. Goswami also digest what is there and then make his submissions. Now you are protected till 9th. So we will fix this matter before that
My lord.
and you get your complete instructions. Can we say that the eviction process will not be carried out till 9th?
That may not be, my lord, expressly written, my lord. I have
Okay.
given, make the
Now
submission.
you have
my lord.
given an assurance. Okay.
Or else, my lord, this will keep on going, my lord. In that situation, my lord, I have to argue on this interim.
My lord, I have a deep respect to my senior friend, my lord. I know, my lord, his statement has never been, my lord, overcome by the authorities. But, my lord, in this.
He'll have to come back to this court only.
That is correct, my lord. But in this type of situation, my lord, if no interim.
For last
order is
24 years, my
given,
lord, I am coming.
No,
And
no,
hopefully,
no.
in few more years, my lord.
For the next 8 years also, he'll have to face me.
No, my lord, we are hoping that he may not,
Okay.
my lord.
But interim, you are pressing that interim, I'm rejecting it.
Yes, my lord.
You can go ahead.
No, my lord, till before 9th, my lord.
No.
Before 9th, my lord.
There may not be any
There,
expression.
there
There
will
are so
not
many
be
cases.
interim direction here.
But, my lord, this is
Because of
case,
the
my lord,
fact that
my lord.
I don't find the committee to have exceeded the directions passed by the Supreme Court, nor violated any directions passed.
No, my lord, the committee has not decided the issues on merit, my lord. Just
I'm
for a
sorry.
moment, my lord, just for a moment, my lord, if I may be permitted to read over a speaking order, my lord.
Hmm.
Before the speaking order, my lord, the reply which we have given. my lord,
I've seen that.
categorical reply we have given.
Okay, show me what is the material in the reply. Other than what you told me.
My lord, may I kindly turn to
You
page-
have put it into headings,
My lord,
page 335 onwards.
456 for non-disclosure of the foundational record and demand for production, my lord.
Now, what is this foundational record you are asking for, Mr.?
So foundational record means, my lord, that when the area has been notified of.
That is already
No,
there
no.
in the 1965
That
notification. It is
correct,
in
my lord.
public
But
domain.
whether the area wherein we are occupying, my lord.
That is what
is
was supposed to be examined.
Examined, my lord, examined by the authority, my lord, we have now, my lord, kindly see. My lord, my lord, I know I cannot satisfy my lord, my lord. Even, my lord, if.
You satisfy me with some very, very basic issues.
No, my lord,
Now you come to your objection.
My lord, the impugn notice, my lord, at page 458, clause 6, I have said, the impugn notice cites an order number dated to claim that.
Where page?
My lord, I am reading page 458, my lord. Page 458, my lord. Is, however, the impugn notice does not enact the said notification order.
It did not, because this
My
is
lord.
not a notification within their records. This is a public domain notification.
No, public domain notification, but they are relying on this, my lord.
Naturally, it
They
is
are
a public
relying-
domain document notification.
My lord.
It is available to everyone. It was available, if not to the clients of Mr. A.R. Burmia, it was available to Mr. A.R. Burmia right from the day when he approached the single judge in the earlier round of litigation.
Yeah, my lord.
A.R. Burmia.
My lord. No, my lord, my contention is not.
Rose by any name will still smell the same.
My lord, my contention is not that, my lord, with all respect to the observation made by my lordship, my lord. My contention is that, my lord, when a prosecution alleges that you are occupying a certain forest land, it is their duty to prove beyond all reasonable doubt that yes, this is the area, this is the map, and this is house A belongs to the petitioner number 1, fall within the map area, my lord. Till date, my lord, they could not satisfy this, even in the apex court also, my lord.
In the apex court,
My
when
lord.
the apex court was passing the directions,
My lord.
why this argument was not developed by you? That, see, you are relying on a notification, but that notification has never been given to anyone.
No, no.
Then the Supreme Court in its directions would have made a observation
My lord.
that while issuing the notification,
My lord.
also include therein the notice to you, include therein the notification declaring number area as a reserve forest.
My lord, though those issues has been pleaded before the Honorable Apex Court in various a series of
So
affidavits.
you brought
have been
this
filed.
notice.
Yes, yes, my lord.
The court
no,
has not noticed, that means
my
it's
lord,
gone.
no. Notice we have not brought, my lord. It is there, some
No, no,
Google
no.
map.
No.
Some,
That contention of yours,
my lord.
that because it's on record here.
My lord, this contention was brought into the notice of the Honorable Apex
But
Court.
the Apex Court did not.
No, my lord, may kindly appreciate, Honorable Apex Court did not decide the issue on merit.
No.
No, my lord, my lord, may kindly see the paragraph of the Honorable Apex Court order, my lord.
It is said that merit thing is
My lord.
with regard to your possession,
No,
your
no,
right
no,
to
the
possess.
entire merit, my lord. And my lord, may kindly see the language of the Honorable Apex Court, my lord. I am just bringing again my lordship's at page 270. My lord, page 270. Yes, my lord. Page 284 is the relevant part, my lord.
No. Let us come back to the directions.
Yes, paragraph 13, my lord. Paragraph 13 at page 283.
You come to page 281, clause 2.
The said committee shall, this one, my lord. The said committee shall issue notice to the alleged unauthorized occupants and shall give them an opportunity to adduce evidences to show that they have the right to occupy the land which is in their possession. Now, my lord, we have tried. Now, my lord, this entire judgment is required to be read together, my lord. Now, my lord, may kindly turn to page 283, paragraph 13, my lord. I am traveling again for my lord.
No,
my lord.
please do so.
My
We are
lord.
also trying to understand.
My lord, in our opinion, the course of
You
action.
can leave that, come to the last line.
Yes, my lord.
1, 2, 3,
Last
4
line,
lines.
the parties are directed so and so, speaking order is passed within 50. All contentions, my lord. All contentions are kept open to be agitated before the committee. It is clarified that this court has not expressed any opinion on merits of the claim of the parties, as the same has to be examined by the committee. So, my lord, therefore, the committee is required to decide the entire issue, my lord, in our reply, my lord.
Yes.
That has not been done, my lord.
Yes, now you come to the notice.
Yes, my lord. The notice of at page 287, my lord. Whereas it has been found that you are in occupation of a land situated within the notified forest area of the Doyang Reserve Forest, notified wide number so and so valid authorization. These are the numbers, my lord. Whereas you have already been issued notice so and so. Now, therefore, in pursuance of the said mechanism and on behalf of the district level committee for removal of the forest enforcement constituted for the purpose notified wide so and so of Environment, Forest and Climate Change Department, Government of Assam, you are being given another opportunity to adduce evidence in support of your claim of authorized occupation in the said notified area. You are hereby directed to submit documentary evidence, if any, within 7 days from the date of receipt of this notice, to establish that you are legally authorized to occupy the above forest land. You are further informed that the committee shall examine the documents produced by you and determine whether the land in your occupation falls within the said notified forest area that you are legally authorized to occupy the said land. It is found that the land falls outside the forest reserve forest within the revenue limits. The matter shall be so and so to the revenue department. If upon scrutiny you are found to be unauthorized occupation of the said notified so and so, shall be passed to served upon you, granting 15 days time to vacate the unauthorized occupation in accordance with law. So your written submission along with the supporting documents must be submitted to the office of the undersigned within 7 days from the date of receipt of this notice. In case no representation, so these are, my lord, the now, my lord, basing on these notices, we have submitted our detailed reply. What is our contention? What is the documents? How we can occupy? Now, my lord, round A, B, C, D, we have, my lord, several, my lord, the entire merits has been, my lord, we have surrendered before the, my lord, the committee, my lord, which has been constituted by the authority. Now, how the committee have very casually, my lord, may kindly peruse the speaking order, my lord. Sorry,
Para 2, page 470.
My lord.
Second one, second para.
My lord. Para 2, my lord, and whereas this one, my lord, and whereas upon a joint verification and the field inspection of the number reserved forest conducted by the forest and the revenue official, it was found and recorded that the noticee is in unauthorized occupation and falling within the notified boundaries of the number reserved forest. Now, my lord.
Now, Mr. Bhia,
My lord.
this is a specific allegation which is there in the notice also. The allegation is that the land that you are having is outside the bound, it's within the boundary of
Forest.
number forest.
Forest.
Now, where is the material to show that this is the boundary and I am residing outside? Because that notification is a public domain notification.
No, that, my lord, the notification we are not denying, my lord. My lord, it is the, my lord, we are not the government, we are just a mere, my lord, landless citizens, my lord.
No, but
but-
when you are asserting a right,
That is correct, my lord.
when you
The
are
right,
asserting a right, the
My
only thing you got to prove is
my lord.
that Mr. Notice issuer, this is what you say, but this is your boundary. I am here, kindly make a investigation.
No, my lord,
Then we
tomorrow-
have a material
My lord,
to understand, okay, this is the issue.
my lord,
That is what is missing.
my lord, that situation may arise in any place in the state of Assam. Tomorrow, if the government come, my lord, bring a notification of 1950 and saying that Hathigaon was a reserve forest area, then my house will also be within the forest area, my lord.
Because Mr. Bhuya,
My lord,
that statement of yours, that submission of yours
my lord.
is a course of action required to be taken, because if an area is declared as a reserve forest, even the government does not have the power without de-reserving it by following the procedure under the act
Act, my lord.
to allow human habitation there.
No, my lord.
Why you? Tomorrow the High Court is found to be within a forest area, this will also have to be evicted.
My lord, that is
There
correct. That is
cannot
correct.
be a second
My
opinion.
lord, for that rescue, my lord, for in such a situation, the Panchayat Act and the Constitution, Article 243 is come into our rescue.
What happens if there is a wrong application of that? The forest laws will have primacy, not the revenue laws.
My lord, if for that, my lord, I beg to draw my lordship's attention to the Assam Panchayat Act, Section 5, my lord.
That has already been gone into by the Supreme Court.
No.
It is quoted in the order.
No, quoted in the order, my lord, but merit has not been decided, my lord.
Okay.
My lord.
Page.
My lord, page 23. Section 5, my lord. Establishment of Gaon Panchayat, the state government may by notification declare any local area comprising a revenue village or a group of revenue villages or a forest village or a tea garden area, elements forming a part of the revenue village or forest village of a tea garden area or other such administrative unit or part thereof to be a Gaon Panchayat with population of its territory as per the so and so within the district falls. Category so, my lord. The section 5 has clearly says that within the Gaon Panchayat area, a forest village can also be extended.
Now,
So-
are we taking it up for final disposal?
No, my lord, no, my lord. No, my lord. If my lordship, my lord, some interim protection, my lord.
No.
Come.
Whether if you want it to be taken up for final disposal, because the detailed arguments have been made, it will be the same thing passing an interim direction, or I have to go through everything. We'll take it up for final disposal.
I'm ready, my lord.
Today, my lord. My lord, the my lord, my contention is that.
Everything is here.
Everything is here, my lord. Let them come up with an affidavit, my
What
lord.
affidavit will they file?
They
Mr. Goswami will not go beyond page 470 to
Taking
472. He will always bring me back there. So I know no affidavit is required.
But
And if it causes prejudice to them, my final order goes in your favor. I'll record that Mr. P.N. Goswami had submitted that the matter can be taken up. Then let him go and fight it out. Anything more, Mr.
No, my lord, my submission is that, my lord, the
I got it.
merit,
Your submission is, if I've understood,
my lord.
one, we are in a declared Gaon Panchayat area. It is notified, and basing on that declaration, we being residents of that area, we were given PMGY house, we were given job cards, we were given every facility. So your basic thing is that although we may be unauthorized, we are not unauthorized occupants of forest area, but unauthorized occupants of revenue land. And by virtue of our long occupation of that land, we have some rights have vested on accrued to us. That cannot be ignored by the state. If it is revenue land, kindly settle that land with us. That is it.
Yes, my lord.
Anything more than that?
No, my lord, the more thing is that, my lord, as the committee has not decided the merit which we have
Okay,
placed.
the committee has
Therefore,
also
my
not
lord-
decided on the
Therefore, my lord-
merits of the matter.
Therefore, my lord, can the matter be remanded back to the committee for a fresh adjudication basing on our reply and the
Documents.
merit, my lord?
Merit. Got it.
A de novo,
But
My
a
lord.
query to you,
my lord.
whether you have any document to show that you have a permissible possession of the land, whether forest or revenue, given to you by a competent authority of the government. Your reply was that no, but we are in revenue land, not in forest land. That is
No,
basically.
my lord, the boundary and the demarcation has not yet been carried out in a proper manner, my lord.
Okay, Mr. Yes. First question. Is submission that you have not delineated or demarcated the boundary of the forest. Then how do you proceed to say that Merapani village or Nirajuli village falls within the forest area and not a revenue area? He tries to solidify that argument or support that argument by saying, see, these are materials, PMGY house, Aadhaar card, this one, that one, all given to me by the revenue officials because I am in a revenue area, not a forest area. Right? What do you have to take? Is your take on that?
Well, when a forest is notified, finally notified under section 17 of Assam Forest Regulations, limits are fixed in the form of coordinates. It is very easy for us to, my lord, take the coordinates and to figure out who are inside or who are outside, my lord.
So your statement is that when
Coordinates are already disclosed in the
when a forest is declared as a reserve for when an area is declared
as a reserve forest under section 17 of Assam Forest Regulation. Final notification. The limits of the forest is specifically declared in the form of coordinates and, my lord, CIDL,
under regulation
regulation 617, my lord,
of the Assam Forest Regulation.
1891, my lord. Limits are, my lord, disclosed in the form of, my lord, CIDL of the land
Disclosed.
and the geo coordinates, my lord.
Disclosed in the form of?
There will be a CIDL, my lord, north, south, and, my lord, coordinates, my lord, longitude and latitude, my lord.
And in the earlier notifications, they say issued prior to 1980 or something, these coordinates were still there.
I am not sure, my lord, that should be there, my lord, because coordinates are usually there, my lord. And schedule is also there.
Because coordinates is not a new thing. It's there from very ancient times.
So from my lord, Assam Forest Regulation says, once the government intends to declare a reserve forest, there will be a preliminary notification. Then because before that the lands will be revenue land or normal unsurveyed land. So what will happen, my lord? The government will issue a preliminary notification asking for claims. And those claims will be settled by a settlement officer in terms of Land Acquisition Act. Once, my lord, final notification under Section 17 is issued, Regulation 17 is issued, there cannot be no fresh accrual or no existing right inside that forest.
Section 17 provides for that.
Section, my lord, Section 18 and 21 also. Then next, my argument would be, my lord, it was the continuous claim of the petitioners that forest has to come up with evidence, revenue has to come up with evidence indicating that they are residing inside a forest. This was a submission made before the Honorable Single Bench, earlier the Honorable Litigation, Honorable Division Bench. Then same argument was made before the Honorable Apex Court. Though, my lord, Honorable Apex Court has said that the court has not decided on the rights of either parties, but this was not on rights, my lord. This was a claim made by them before Honorable Supreme Court also that state has to come up. Despite that, my lord, if we again turn to the Supreme Court's order for a moment, my lord, that was a ground, that was a point raised by them that state has to establish. The Honorable Apex Court, my lord, page 281, my lord, 12.2, my lord. The said committee shall issue notice to the alleged unauthorized occupants and shall give them an opportunity to adduce evidence. Who will adduce evidence? My lord, the occupants. Alleged unauthorized occupants will adduce evidence. In this order, there is not a single whisper giving sorry.
I had sought a clarification from Mr. Bhuya on this point only.
So therefore, in my humble submission, my lord, it's a case of constructive res judicata. They raised that point that state has to come up, but the burden is not on the state now. It is on them only, my lord. It is on them. Then my lord will kindly
Mr. Goswami, the issue is not whether they are an unauthorized occupant or not. They are an unauthorized occupant over the land.
Maybe revenue, maybe forest. They are saying revenue because
you say forest. That's the only issue.
Yes. Because revenue, my lord, they have why they are saying so from the very beginning, despite there being no document, no evidence. Why they are saying so? My understanding, my lord, because in that situation, they have a better claim for getting an alternate land. Paragraph.
Absolutely, they will do that.
Yes, my lord. The land policy will come.
They are landless people staying there. So if that is an opportunity available to them, why will they not?
Definitely. But even if, my lord, if they are landless people residing inside forest land, under the land policy of 2019, then also they can make a claim.
Okay. Anything more?
Paragraph 6, my lord. 12.6. If an unauthorized occupation is found in a reserve forest area, after scrutiny of documents, this document means the document submitted by the petitioner. A speaking order shall be passed so and so. So now, if my lord will see their reply to our notice that my lord finds at page 305. Page 305. My lord, in fact, going through this reply, when they file, I could very well figure out, my lord, this is a clear my lord, attempt to make a fresh cause of action, my lord. My lord will see what they say. They have written to the district level committee, paragraph 2. At the outset, I deny the foundational allegation, the page 306, my lord. A foundational allegation contained in the impugned notice that my dwelling house land is situated within the notified forest area of Doyang so and other reserve forest. The impugned notice, while making a sweeping assertion, does not annex or disclose any statutory notification, boundary map, cadastral overlay, demarcation scratch, GPS-based survey report, and or any other reliable legally reliable material establishing that the specific plot household is in my occupation falls within the boundaries of any reserve forest. In the absence of such disclosure, the allegations remains a bare assertion, incapable of being meaningfully answered, violation of minimum standards of procedural fairness. Procedural fairness, my lord, Honorable Supreme Court has already said it has been properly granted, my lord. So, my lord, now, my lord, the intent of the Honorable Supreme Court's order was to afford them an opportunity to adduce evidence. They have basically, my lord, reversed the position. It is now on the state. They claim, my lord. Now, my lord, will see it is their own case. It is their own case. Despite that, they say paragraph 4, my lord. Further, without prejudice to the above, I also respectfully question the legal foundation of the present committee itself. The notice states that the committee has been constituted pursuant to the mechanism recorded by the Honorable Supreme Court and White so-and-so number 17/2026. However, the notice does not disclose statutory provision. We all know, my lord, it's an order passed by the Honorable Supreme Court. What is the requirement of a statutory provision? Well, it's a desperate attempt, my lord, to basically remain inside a forest.
I had asked that also to Mr. Yeah, he did not press into that further, only saying that he made a submission that this committee ought to have been notified earlier.
Yeah, it's notified, my lord.
That is his submission. But this committee was notified on 17/2/2026 itself.
Exactly.
And thereafter,
Notice-
assuming office or the entering into that inquiry, it had issued the notices.
Yes.
It made a inquiry, field inquiry, thereafter found, at least that is what is reflected from the order. And then it went ahead and issued the notices. So these are issues, I think, very issues.
And
Come to the
on merit, my lord, law is absolutely clear, my lord. Electricity connection, Aadhaar card, PAN card will not give any claim over a land, my lord. Be it occupancy, be it settlement holder, my lord. There is no record to indicate, my lord, neither patta, neither settlement order, my lord, allotment order. Nothing is there in favor, my lord. It's not in only one case, in every case, my lord. There is no document to indicate, they have no evidence, as was directed by the Honorable Supreme Court, to adduce evidence showing that their occupancy is valid.
That they are rooted to that land.
Exactly. There is nothing, my lord.
Permission.
There is nothing. And finally, my lord will kindly appreciate one thing. I am also disputing that they are inside forest, my lord. They are also disputing they are not inside forest. How this read court will decide? It's a certiorari jurisdiction, my lord. These type of questions of fact cannot be decided, my lord. It's not impossible. It is not possible, my lord.
Mr. Goswami,
My lord.
on that count, we will not non-suit the petitioner.
True.
Because he is here in pursuance to an exercise directed to be carried out by the
Honorable Supreme Court.
Honorable Supreme Court. Now, the Honorable Supreme Court had laid down around 7-8 points how to proceed with that. Now, if we find that the procedure laid down by the Supreme Court in arriving at that conclusion was not correct, we are within our power to interfere with that.
So there has to be some procedural impropriety, my lord. Where is that, my lord? That's not there. It is not their case. Their case is that state has to come up with evidence.
Basically on the merits of the decision.
Exactly. Merits, how
Which we cannot go into.
Exactly. What I'm on, my lord, merits of their claim, it's not their case that I have a better claim here. What is their claim on merit? That state has to come up with evidence showing that you are inside forest. This is not adjudicatable in this forum. In my humble understanding, my lord, the read court, my lord, is for enforcement of a pre-existing right, not for declaration of a right. If anybody who comes to this honorable court has to come with a pre-existing right for enforcement of that violation of that right, my lord. It's not for declaration. They're basically trying to reduce this forum to a, my lord, trial court, my lord. And certiorari jurisdiction, my lord, we all know, it's not possible, my lord, if there is no proprietary irregularity. And if we, my lord, see the speaking order for a moment, just 2 paragraphs. I'm not praying, my lord, they should be made non-suited, my lord. I'm praying that this the kind of writ petition should not be entered and should be dismissed. Page 470, my lord. Second paragraph from bottom, my lord. And whereas the noticee, instead of producing any documentary evidence in support of a lawful claim of right, title, or interest over the subject land, such as valid patta, registered sale deed, settlement order, title under Forest Rights Act, or revenue receipt against the said land, or any other legally cognizable instrument, has sought to question the validity of the notification declaring the area as reserve forest, the authenticity of the notified boundary and related records, the constitution of the jurisdiction of the committee itself, and the burden of proof, asserting that the state is obliged to first establish territorial boundaries before any adverse determination.
Next one also.
Yes, my lord. Now, my lord will see on merit what we have. So what I was on actually, my lord, that they cannot also make out a case that we have not applied our mind. The speaking order itself indicates, my lord, appropriately applied.
Where is that 17(2) notification?
It was a notification pursuant to Supreme Court's order filed by the same petitioners.
Mr. Bhuyan, in your this writ petition, have you alleged any malafide against the district commission?
No.
No, my lord, this notification is first time came to my notice, as well as the no petitioner has is aware about this notification, my lord. How, in what manner they have issued, that is also.
In terms of
That is, Mr. Bhuyan, that will not be maintainable because in the notice itself, this reference is there.
No, my lord, if it has been notified, my lord, by following the due procedure of law, then we do not question that thing.
This is by
My
the
lord,
by the Supreme Court thing.
my lord,
We will not question
lord.
that.
my lord. My lord, only thing is that, my lord, my respected senior friend has categorically dealt with the entire matter, my lord. But this panchayat matter has not been
And
replied
he's
yet.
not completed. He's I think still has some
My
more steam to come out.
Page
Yes.
4,
Yes.
page 471, my lord, then same
471.
speaking order.
Hmm.
Serial number A, my lord. The number South Reserve Forest was duly notified by government notification order number so and so dated 15/9/1965.
You can skip A, B, C from onwards.
And in A also, last line, such notification also
We have gone
contains
through
it.
that.
Vivid
It's C
declaration.
onwards.
That upon detailed verification of the committee members, by the committee members, it has clearly emerged that the notice is an unauthorized occupation, is in unauthorized occupation of number South RF. As per directions of the Honorable Supreme Court, opportunity to claim lawful right to occupy the land was also afforded to the noticee, but the noticee had tried to shift the burden to the state authorities and failed to adduce any cause and evidence in his favor. A joint field verification by committee members using ground survey and GPS coordinates also has conclusively established that the noticee's occupations falls within the notified limits of number South Reserve Forest. Despite this opportunity, the noticee has produced no document conferring right, title, or authority over the said land. To establish lawful authority over reserve forest and forest land, a claimant must produce a document of lawful diversion of the said forest land under one Sanrakshan Evam Sambardhan Obhiniyam. This is my earlier Forest Conservation Act 1980, earlier known as Forest Conservation Act, or titled under the Forest Rights Act 2006, or documentary proof of being bona fide forest villager of a village duly notified, recognized by Forest Department. The noticee has failed to produce any of these. The documents relied upon by the noticee like
Mr. Kusami,
my lord.
is there a list of documents which they have placed separately given? Page 363.
Page, my lord, 362.
363. These are the documents you give.
My
Yes.
lord, along with our replies, my lord.
Now, my lord, that
Is there any revenue receipts given here, Mr.
no, my lord.
Tojibahi revenue?
No.
Okay.
And my lord will kindly appreciate one thing, my lord, that Panchayat Act, they're saying the Forest Right Act. Forest Right Act, Forest Conservation Act. Assuming, my lord, Panchayat has declared some area to be a village inside that, whether Panchayat has yes, Panchayat has jurisdiction to do that, my lord. Firstly. Secondly, my lord will kindly peruse Forest Conservation Act 1980. Paragraph, sorry, section 2, my lord. Restriction
Oh,
or...
wait, let me find it out.
Oh, my lord. Ekhon kitab likheni.
Forest Conservation Act 1980.
Yes. Bye.
228. Yes.
Section 2, my lord. restriction on the reservation of forest or use of forest land for non-forest purpose. It says, my lord, notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, may order directing, serial number 2, that any forest land or any portion thereof may be used for any non-forest purpose. So, my lord, all law of the state will go. Have to surrender before this law, my lord. It starts with the word notwithstanding anything contained in any other law. So that argument, my lord, cannot survive. Honorable Supreme Court's order, my lord. But if we see once. Page 282, my lord. Paragraph 7. Serial number 7, my lord. Occupation of a Gao Panchayat in a forest is permissible if there is sufficient proof as per the Jamabandi register maintained by the Forest Department or as provided under the Forest Rights Act. And in our speaking order, we have clearly revealed, my lord, there is no such record. Okay. Obliged, ma'am.
So what do you want us to do? Dispose of the petition or pass up, consider the interim prayer? Choice is yours.
Interim order, my lord, allowing us not to.
Allowing, dismissing, rejecting, what that is, leave it to the court, but.
No, my prayer only. my lord.
That is
Lord,
the
only-
accepted. But by going to do the interim prayer, we'll have to go through the whole
My lord.
thing. So we dispose of the petition
My
itself.
lord, only one thing, my lord, I have not argued before my lord as
Hmm.
regard the panchayat issue.
Hmm.
My lord, my learned friend has says that the entire law in view of the 1980 Act will go. My lord, any law which the parliament is entitled to make, but my lord, it cannot override the constitution, my lord. It is a well settled principle.
That is,
No.
that issue in a 486, repugnancy, this.
No, my lord,
that we will
why,
consider.
my lord, why I am
No,
making
it
that
is-
submission, my lord, the constitution, my lord, the part 9 of the constitution specifically deals with the panchayat, my lord. Just for a moment, my lord, if my lordship may be
Yes, it's
permitted,
true,
my lord.
please.
Well, generally, my lord, we never go through, my lord, when it requires, my lord.
Hmm.
Article 243, my lord, part 9.
Hmm.
In this part, unless the context otherwise requires, district means a district in a state. Gram Sabha, my lord, may panchayat area, panchayat is defined at D, my lord, means an institution by whatever name called of self-government constituted under Article 243B for the rural areas. And now, my lord, the panchayat area means the territorial area of a panchayat. And my lord, 243B says, Constitution of Panchayats, there shall be constituted in every state panchayat at the village, intermediate and district level in accordance with the provision of this part. Now, my lord, the panchayat which has been constituted
Is
by
under
a
this.
notification, my lord, has a force of this part 9 of the Constitution. Now, my respected friend says, my lord, after the 1980 Act, this Panchayat Act or the Panchayat provision, everything will go. My lord, it cannot override the
No,
constitution.
I'm not
my lord.
saying entire Panchayat Act will go,
Well-
my lord. The provision that he's saying that there will be.
Where there is an overlapping of the forest area
My lord.
and the
Exactly,
panchayat area.
exactly.
To the extent of such overlapping,
My lord, may I
the
suggest one
forest
thing?
act would be
My-
the.
May I suggest one thing, but let notice go, my lord, without any interim order, my lord. There are 6, 7 cases filed fixed before 9th, my lord. If possible, I will come up with an affidavit, my lord.
And my lord,
Mr.
my learned friend has assured that till 9th, nothing will happen.
That assurance he has withdrawn.
No, he has not.
Heard Mr. A.R. Bhiya,
My
on the
lord.
counsel for the petitioner. Okay, there are few other matters also.
My lord.
Let notice go. That's right.
We'll issue notices and the consideration on interim prayer. We'll do it at 2 p.m., but we'll hear the others now only. Yes, which is the next matter?
All are same, almost same. My lord. Let
Similar-
notice go in every case, my lord.
Similar matters, my lord.
All.
my lord,
No,
I
no,
think
Ms. Chaudhary is also having one matter.
Also here.
Same argument? Same argument as Mr. Bhiya.
I'm
Right.
giving the items, my lord.
Huh.
Item 23, 24.
Oh, that has.
Oh, sorry, it has been
amendment.
28,
Number to send on.
renumbered, my lord, 28, 29, 30,
Just no. First is
28,
24.
28, my lord. Now it is
28.
28. 29.
List to go to. Just no, just no.
কাগজত লিখি দিব পাৰি।
I'm giving all the
That was
numbers.
a lie.
Item 28,
Just no.
milestone.
Huh.
Item
28,
28, 29,
Hmm.
30, 31, 33, 34, and 35.
33, 35.
34 also, well.
34 also.
Well, 28 to 35, except
But
32.
32 is something different.
Except 32, madam.
Now, the forest area involved in all these cases
Different,
are
sir.
different forest.
Forest study.
Can you, somebody just
Yes,
write
ma'am.
down?
Well,
Both of you.
will do.
The item number
Case wise
12,
forest,
Case
these are forest.
villages and forest
My lord.
covered. Order is basically the same.
Notice, my lord.
Okay, we'll issue a notice. He wants a notice, we'll issue a notice. And the interim prime will pass the orders in the second half. 2 p.m.
My lord.
Because if I start doing this, we are rising at 3:15 today. Others will have to just wait.
So my lord will be taking up these cases again at 2
At
p.m.
2 p.m.
My
and
lord.
pass the orders.
My lord.
So was that more remote again? Come to delay. Thank you.
Deeply
Obliged,
obliged.
obliged, my lord. Deeply obliged.
Yeah, madam. 32 hey Purana to examination.
Please, your lordship. Conducting council, MI Hussain is another court. Kindly pass for the matter for the time being.
The timing. Oh, it to tie. It all of the media. Probably.
Earlier,
Mr. Chaudhary, Mr. Monto, what are you all waiting for? Okay, we'll just finish up a few and then take up. And Mr. Chaudhary?
Item 18, top of the list.
That direct recruitee and promotee. You are for the direct recruits.
Yes, madam.
And Mr. Tiwari is for the, we can get him, we will take up the matter. Next, Moyuri guy. Yeah. Yes, Mr. Sharma. What is your instruction?
Three of the incumbents is continuing, but their appointment is prior to the removal of this petitioners.
There were 3 other
Yes,
incumbents. How do I know that?
that is the order. The petitioners in their additional affidavit, they have stated that 5 persons are working, but appointed after the removal of this petitioner, And here, Raju Das, is working 2017, And the appointment on Prime Minister that Abbas Jojana scheme,
Okay.
Then, second one,
These are the people who have been named in the
yes,
additional
yes,
affidavit.
in their additional affidavit, And second one, was appointed on compensatory ground, That, Kobir Chandra Roy. Second one,
You've given me.
Yes,
Provi Chandra Roy is here.
Yes, second order, 12/9/2007.
Provi Chandra Roy.
Yes, And third one, that
No, let us just have that
Yes.
affidavit.
paragraph 5, page 3.
22. Pritam Patgiri?
Yes, Madam. The third one, Madam, that last page, Madam. He was also appointed.
16 to 19.
Yes, but he was appointed under scheme, my lord.
Okay.
Prime Minister.
Himanshu Roy?
No, my lord. He's not working, my lord.
Kabir Chandra Roy, compassionate.
Yes, my lord. Then, my lord, Monilal Sohan also not working, my lord.
Raju Das is also there.
Raju Das?
Yes, my lord. He's working, my lord. He was appointed as a data entry operator under my lord PMAY scheme, and he was appointed on 3/7/2017, my lord.
And Monilal Chauhan.
He's
Not
not
working.
working. Not working, my lord.
Now, he
Kabir
was
Chandra
appointed,
Roy-
my lord. He was appointed, but probably now discarded.
No,
No,
my lord.
whether he was appointed at that
Yes,
point.
he was
My
appointed.
lord, he is retired, my lord. Long back he was retired, my lord.
Oh,
As
he's
per
a retired
my-
employee.
yes.
After retirement, he was taken back.
No,
That
my-
is the case. Some few retired employees
No,
were
my lord.
taken.
As per my instruction, no, my lord.
Okay. Pritam Patgiri
Pritam
is
Patgiri,
working.
my lord, he was appointed under the scheme, my lord.
Mr. Vishwas,
Yes.
your Pritam, if you can come to page 27, your additional affidavit.
Page 27. Which item, my lord?
First item,
First item,
956.
Govindo Das.
page 27. Ikano.
Petition.
Page 27. Affidavit. Fine.
Additional affidavit that you have filed. Second one.
956. Second one.
3/10/2020.
27 कहाँ है? Page 10 कहाँ है? Yes, madam, that is a judgment.
No. The internal page 3 of that.
Kulojit Das.
Yes.
Para 5.
That the petitioner begs to state that instead
That
of,
we have got it. Pritam Patgiri
yes,
is working, but he is working from 16 to 2019 under a scheme. Then Himanshu Roy is not working.
Yes, madam.
Kabir Chandra Roy was appointed on compassionate ground.
August 20,
12/9/2017.
and re-engaged Manilal Chauhan and Raju Das.
Re-engaged Manilal is not working. Raju Chauhan has been re-engaged as a data entry operator. So specific nature of work. So you're that general MTS type of work, there was no engagement. So in this view of the matter, and in Govinda Das, your plea for compassionate appointment will also not be sustainable because your mother has already been
Yes,
appointed.
that's true.
So that goes. So Mr. Das, Biswas, we'll have to interfere with this, allow this. No interference is called for with the thing.
My only prayer that in future the master who is appointed, our case may be considered.
Yes, sure. Heard Mr. S.C. Biswas, Learned Counsel for the petition. Also heard Mr.
Yes, तीनों एक ही होगा.
A.K. Sharma, Learned Counsel appearing for the Bilasipara Municipal Board. That is the respondent number 5, 6, and 7. Any Mr. N. Das, Learned. MAD, Municipal Administration, you can appear, Municipal Administration. Yes. Mr. N. Das appears for the respondent number 1, 2, 3, and 4. It's A.K. Sharma, 5, 6, 7. The bottom today. How many matters are there? 3.
Three.
The petitioner in the present writ petition by way of instituting the present writ petition, has presented a challenge to an order dated 31/12/2019 issued by the Executive Officer, Bilasipara Municipal Board. That is the respondent.
Excuse me, in writ petition 334 item, they are visually called Dimple Kalita, daughter of the Bilasipara BJP president, has been engaged as a respondent number 4. He was engaged subsequently after us.
First one we are trying.
Yes, yes.
Then we'll come to that. 31/12/2019, issued by the respondent, respondent number 6, comma. Discharging the petitioner hearing along with 4 others from their engagement as muster roll workers in the board on account of the fact that they were held to be excess muster roll workers. Also, the petitioner in the present writ petition, next, in the writ petition has projected that his father, Ramakrishna Das, while working as a grade 4 employee, Mr. Please have a seat. Please have a seat. While working as a grade 4 employee in Bilasipara Town Committee, Kumar had died in harness in the year 2002, leaving behind the petitioner. Leaving behind the family of the petitioner in Penuri. It is projected that the petitioner had approached the authorities of the Bilasipara Municipal Board, the Bilasipara Town Committee, now Bilasipara Municipal Board, bracket over, praying for his appointment on compassionate grounds. Also, the petitioner further projects that it is on the basis of such application that the petitioner came to be engaged as a night chowkidar on muster roll basis with effect from 1/7/2017, while issuance of an order of engagement dated 5/9/2017. He further projects that the said engagement was in pursuance to a resolution adopted in this connection by the Bilasipara Town Committee. The petitioner projects that he continued in his services till 19/5/2018 when he was discharged from his such engagement. Thereafter, the petitioner was again re-engaged as a muster roll worker with effect from 5/12/2018, again as per the resolution adopted by the Town Committee. It is in the above background that the petitioner was discharged as a muster roll worker again, while issuance of the impugned order dated 31/12/2019. The petitioner, by projecting that the ground assigned in the impugned order dated 31/12/2019, that he was an excess muster roll worker, was clearly perverse, inasmuch as after his discharge from his disengagement from his muster roll services, the respondent authorities had proposed to engage further muster roll workers. Accordingly, being agreed, the petitioner had instituted the present petition. Mr. S.C. Biswas, learned counsel appearing for the petitioner, after reiterating the facts noticed herein above, has submitted that the respondent authorities had not considered the case of the petitioner for appointment on compassionate grounds, although his first initial engagement effected while the order dated 5/9/2017 with effect from 1/7/2017 was in fact engagement so made by recognizing that the family of the petitioner, on account of the death of his father, was in need of a source of income, and accordingly, the said appointment is to be construed to be one made by application of the principles of appointment on compassionate grounds. Mr. Biswas submits that the petitioner, after having rendered services in the municipal board for a considerable period of time, came to be disengaged. The petitioner, after having rendered so and so, came to be disengaged by an order dated 31/12/2019, and the ground assigned therein was that the petitioner was a excess muster roll worker. He further submits that from the pleadings brought on record by the board authorities, it is evident that the petitioner's services was mandated to be so disengaged. Petitioner was mandated to be so disengaged from his muster roll engagement only on the ground that the board did not have adequate funds to provide for the salaries or for the wages to the petitioner and other muster roll workers disengaged along with the petitioner while the order dated 31/12/2019. Mr. Biswas submits that after the disengagement of the petitioners, the board authorities proceeded to effect further engagement in respect of three outsiders as muster roll oblique fixed pay basis, and also re-engaged two ex-employees of the board. So he submits that the said engagement oblique re-engagement effected in the board after the termination of the petitioners. After the disengagement of the petitioners from their muster roll service would go to reveal that the plea taken by the petitioners about lack of fund was just a cover-up to legalize the disengagement of the petitioners, and submits that as projected by the petitioner in the writ petition, such re-engagement was only for the purpose of engaging persons close to the members of close to the powers that are there in the board at the relevant point of time. In view of the above premises, Mr. Biswas submits that the impugned order dated 31/12/2019, insofar as it concerns the petitioner hearing, would mandate an interference. He further submits mandate an interim with further direction to the respondent authorities to re-engage the petitioner in muster roll capacity. Mr. Biswas also submits that in the event this court on consideration finds that the order dated 31/12/2019 would not mandate an interference, he prays that the board authorities be directed to consider the case of the petitioner in any future engagements made on muster roll oblique fixed pay basis in the board, and to engage him in such capacity by recognizing the services rendered by the petitioner since the date of his initial engagement, with effect, that is with effect from 1/7/2017 till 31/12/2019. By contra, Mr. A.K. Sharma, learned counsel for the respondents, have submitted that the plea of the petitioner for being considered as a compassionate ground appointee would not mandate an acceptance, inasmuch as after the death of the father of the petitioner, the mother of the petitioner on compassionate grounds was engaged on muster roll basis, and thereafter her services were regularized. On the day, he submits that on the date the writ petition was so filed, the mother of the petitioner was continuing in his services, and accordingly, no further member of the deceased employee, member of the family of the deceased employee, was permissible to be considered for appointment on compassionate grounds. Mr. Sharma submits that the resolutions adopted by the board in the matter, which had led to the issuance of the impugned order dated 31/12/2019, would go to reveal that such a course of action was mandated to be taken by the board authorities, considering the fact that there was dearth of funds in the board to pay for the wages, pay the wages of such excess muster roll workers appointed. With regard to the plea raised by the counsel, raised by the petitioners, petition that after the disengagement of the petitioners, the respondent authorities had proceeded to make further engagement on muster roll / fixed pay basis, Mr. Sharma on instruction submit that 3 persons were engaged in such capacity. However, submits that that out of the persons named by the petitioner in his additional affidavit dated 3/10/2020, 3 persons were in fact engaged in the department. However, such engagement was prior to the date of disengagement of the petitioners. He submits that Pritam Das, who was projected to have been engaged by the petitioner on 14/8/2020, was in fact engaged by an order dated 16/2/2019 on a purely temporary basis for 89 days in view of the urgent nature of works arising under PMAY bracketed EU schemes and allied works. Also, with regard to the projection made in respect of Himanshu Roy, the Mr. AK Sharma submits that they said person was never engaged in the board in any capacity. With regard to Kabir Chandra Roy, with regard to the projected engagement of Kabir Chandra Roy in August 2020, Mr. Sharma submits that said Kabir Chandra Roy was in fact engaged by an order dated 12/9/2017 on compassionate grounds as a driver. Also, with regard to the re-engagement of Manilal Chauhan and Raju Das, Mr. Sharma submits that while Manilal Chauhan, an ex-employee of the board, was never re-engaged, but Raju Das, also an ex-employee, was so re-engaged again for a specific nature of work pertaining to PMAYU works. He submits that the nature of works discharged by the petitioners while they were so engaged on muster roll basis, and the works discharged by Pritam Patgiri, Kabir Chandra Roy and Raju Das are separate and distinct, and accordingly, basing on such engagement, which were so made on account of the necessity arising for the same in the board, the petitioners cannot base their claim thereon. Anything more left out?
No, ma'am.
Item number
4, madam. Sanjay Sharma.
it would be a seal. Govindo Das, next to him, 3, Kulojit Das, 95720. So, Becky Obo. Second paragraph, that the petitioner has projected in the writ petition that he was initially engaged as an electric assistant in the office of the Bilasipara, then Bilasipara Town Committee, bracket now Bilasipara Municipal Board, bracket over, on 17/1/2018, as per the board resolution taken in a meeting held on 23/11/2017. The petitioner was disengaged and thereafter again re-engaged by an order, a communication dated 31/2019 in pursuance to a resolution adopted by the municipal board in this connection. The petitioner projects that by an order dated 31/12/2019, 31/12/2019, the petitioner was disengaged from his muster roll engagement on the ground that he was an excess muster roll appointee. Compassionate appointment to Khali Gusai Diba, Baki. So Sabo, Thomas Sabo, Ekiti. Yes, 3, Sanjay Sharma.
Sanjay Sharma.
Here you say that you have some statement. Where is that?
Dimple Kalita, daughter of the Bilasipara BJP president, has been engaged by testament number 4 against the post in which the petitioner applicant was working.
Yes, what do you have to say on that?
My lord, in our affidavit, my lord, paragraph 7, my lord, we have denied them any fresh appointment, my lord.
Not fresh.
Okay.
But still she is working, Dimple Kalita.
Is it?
No, my lord, as per
To our
my
information.
lord, as per my lord, affidavit, my lord, I have stated that specifically stated that no fresh appointment made, my lord. And my lord, in their reply
Okay,
also,
thank
they have
you.
not stated anything, my lord.
The petitioner projects that he was appointed as a master roll worker in the office of the Bilasipara Municipal Board and directed to perform the works of tax collector while issuance of an order dated 8/3/2019. The said order was so issued basing on a resolution adopted in this connection by the board, by the municipal board. Also, the petitioner continued to discharge his duties and there was wide order dated 31/12/2019 issued by so-and-so, respond number 4 over there. Disengaged from his such master role engagement on the ground that the petitioner was serving in was an excess master role appointee in the boards. Also, the petitioner has further projected that, where have you stated that statement?
Additionally, with para 4, my lord. I number 125/121.
I accept.
Yes. During the pendency of the above writ petition, the Dimple Kalita, who is the daughter of the Bilasipara BJP president, has been engaged.
The petitioner has further, by way of instituting an interlocutory application, projected that after his disengagement, for the works for which he was so engaged, one Dimple Kolita came to be so engaged, and it said Dimple Kolita is continuing in her services. Also, Eke Sharma, Eke Thagiba. With regard to the contention of the Learned Council for the petition that one Dimple Kolita was engaged in place of the petitioner after his disengagement, Mr. Sharma submits that Sharma, by referring to the affidavit filed in the matter by the respondent number 4, submits that the said contention is categorically denied and no fresh appointment was made. Further, he submits that while an order dated 5/2/2020, the government in the Municipal Administration Department had planned fresh appointment pending finalization of the staffing pattern in various municipal boards of the state. So, disposed of funds. That observation would be there.
Yes, ma'am.
In the instance case, we are challenging the impugned order dated 29/7/2015, which passed by the Lower Assam Commissioner, which set aside the order dated 17/12/2012, which appointed me as the Gauhati. But since Mr. PDNI is not longer appearing in this matter, my senior Amit Goel is appearing for the last couple of times, but he is out of station to do. So it will be taken up on 20th or any day after that.
You don't require at that point of time a declaration that there were criminal cases pending, civil cases pending. Was a declaration required at that point of time for appointment on Gambura?
It is in the advertisement, it is not.
Not there.
Not there.
Not there.
After 2018, Lordship, 10/4/2018.
It came.
It came.
Literally, yes.
On that time, my lord.
On the date when he was being considered, 2012,
Lordship.
this was He had a criminal case pending
Lordship,
against him.
in person to the
And moral turpitude was a issue.
Lordship.
But that was then subsequently, he was acquitted and there was no requirement that he has to be. Now, if on the date when the authority had considered that, on that day he had a clean sheet in his hand.
Lordship.
What more is required? Yes, you are paying for the private respondent. Yes, what is your stand? Did you raise this issue before the appointing authority at that point?
He's challenging the.
No, you raised it before the appellate authority. No, on the date the appellate authority considered that thing, he was already acquitted.
He was acquitted.
Where is the requirement of declaration of that particulars? There is no police verification required for appointment of a Gauhati.
It is required, Lordship.
But then why this thing had not come out in the police verification?
2010.
Not required.
In 2010, police verification says no case pending.
2000, after 2012, Lordship,
Page
it has
Ah, this is 2010 appointment.
Lordship.
Page
Okay, you have that. Where is that?
Page 17.
Of the writ petition. And the appointment was effected,
12 Lordship.
unfortunate.
And on that time, my lord, that circle officer, my lord, SDO, my lord, they have the power to, my lord, appoint.
Yes.
Okay. In the year 2000, he was fit for job. And moreover, this petition is premature about it.
The advertisement is of 2010. And in the advertisement, he could not have made that disclosure because there was nothing at that point of time.
At that time, my lord,
The election is of 2010.
Lordship.
On the date of this election also, this was not there. After his appointment, something has come up. That will have to await the final outcome then. Hmm? Hmm. Hmm. Suitability.
Yes.
Suitability on 2010, what was the bar? When was this election held?
Advertisement was of 2010.
Ah.
Election was made on 2012. He was appointed.
Then how does this, what is this certificate? This is not police verification.
And Lordship.
There is some lapses on the part of the administrative. That may be
17.
But he was not
17.
fit for job.
17 of. Was that just every piece? Advertisement.
When was the appointment made?
Lordship, 2012, Lordship.
Page 31.
No, that is the appointment.
17.
No, the selection per se took place when?
I took that.
They are applied, Lordship, in the 2010, Lordship.
10 itself.
Lordships.
Amendment made page 31.
Is there any way we can know the date of that selection?
Records actually call for it.
Just get a clarification, that will.
Some time may be granted.
On the prayer of a prayer is made on behalf of a prayer is made on Mr. A. Goel. A. Goel, on a counsel for the petitioner for an adjournment in the matter on account of personal inconvenience. Registry to list this matter again on 24. No further adjournment shall be granted in the matter.
25th.
24. 24-3.
24, no? 3.
Mr. Sinha, you have approached this court after your retirement. By that time, everything is gone. Your employment ceased. Never raised a grievance before that. Amal Satpati, now how can we promote you?
No, yeah, no, promotion means the seniority, my lord, sorry. Yes, my promotion, my lord.
Promotion,
Yes,
definitely
yes, yes.
the other things will follow.
But representation was pending
Be that as it
pursuant to order of this
Be
honorable
that as
court.
it cannot be.
They have also admitted that so and so are, but the authority did not give. They have admitted it, madam.
Fine, but all said and done, you have now, how will you assume the charge of the post? You're
No,
not.
charge now I have already retired.
Give it a closure.
Yes, madam.
We'll get the order on Tuesday.
All right.
Ms. Pukun, you are appearing for?
Then for age itself.
Huh?
Age itself.
As government?
Corporation.
Oh, AGC.
Yeah, he was the employee of APDCL. He has not made APDCL as a party. Your Lordship.
After retirement, he is employee of
Yes,
every.
yes. At the age of 61. Yes.
Your standing counsel AEGC.
GC.
Dismissed.
Obligation.
My lord, we have filed
So
one
opposing you,
affidavit.
Mr. in this, Mr. Chaudhary, in this case.
Yes.
For the government,
Yes, yes, my lord, if your lordship will kindly take the additional affidavit which we have filed.
we have seen it, Mr.
Yes.
Chaudhary. You have traced out the progression of that dark
Yes,
various
yes,
settlement
yes,
period.
Yes.
And 19 is never up.
No,
That
my lord.
lag was never named.
And my lord, if your lordship will kindly see that, affidavit come control, if your lordship would kindly come to page number 68.
Trace map.
Now kindly see the colored portion is our land, 270.
There is a PWD road.
And that's the PWD road. Then what defense land are 429 and 276.
And this 268, this whole is 268.
Yes.
Huh? So
No,
there
my
is.
lord, our land is two.
No. There is this land named as 266 or 268.
Yes.
Just above the defense land.
Yes.
A straight property.
Yes.
This is one property.
Yes.
So that is a buffer between you and.
Yes. In fact, the PWD road is the buffer between us.
No, they have this defense land this side also.
This side also.
Right side also.
Similar, thereafter, we have 267 also.
You have 266, 267, then your land comes.
Yes.
So where is this 19?
I don't know, my lord.
And they have been very consistently behind you from that day.
One more document, my lord, if your lordship would kindly have it.
Who is the CGC appearing? Mr. RKD Chaudhary. Mr.
RKD, yes.
Mr. Gogoi. Mr. Gogoi. Mr. RKD Chaudhary was appearing in this matter.
Just now I verify who was appearing in this matter.
RKD, yes.
I will inform him, Lordship, any.
Kindly see the, my lord, this is my Jamabandi, my lord. Anima Chaudhary is the mother's name. And if your lordship would kindly come to the second page. At some point of time, it was 174, then 61, then 63, then 270. This is the Sita, my lord.
Now it is the latest one.
Latest 270.
Lordship, here in this case, Lordship, interim order is open. So, Lordship, any other date today, Mr. Chaudhary.
No, it's not the question of interim order operating. The question is, why keep this matter pending?
Lordship, Mr. Chaudhary.
Yeah, I got it. Ms. Devi, you just have an instruction from your authorities. Mr. Chaudhary has now filed an additional affidavit. There is already a decision of this court earlier pertaining to 25. It became
25
It became 270. So this court required Mr. Chaudhary to bring it on record how the various settlement processes, how the DAG number was
eventually became 270.
270. Now we find, even from the trace map, that 19 was never a DAG number assigned to this plot. But your notice specifically mentions 19, DAG number 19.
25.
So DAG number 19 has to be yours. From the trace map given by Mr. Chaudhary, we find that presently the defense land is 276 and 429.
Yes.
So this is the latest resettlement DAG number.
Yes.
How did it start? From the period when Mr. Chaudhary's land had DAG number 25 K.
At the time of reconveyance.
Reconveyance. And this court order is clear. Another thing you can tell Mr. Chaudhary also, between the lands of the petitioner and the defense land, there is a buffer land. There is a road. So this court is not getting that. How you have, maybe you have put in a Bailey Bridge or something and then gone there. Or how have you gone? Or this map given by Mr. Chaudhary is clearly wrong. Does not project the correct picture. When can you get it? Next Friday?
Next Friday, Lordship.
You are,
Next Friday. Next Friday.
but Mr. Chaudhary, Learned Counsel for the petition, Learned Senior Counsel appearing for the petition. Mr. Chaudhary has taken the scope through the additional affidavit filed in the matter by the petition in pursuance to the directions passed in this connection wide order dated 25/2/2026 and has demonstrated that the plot of land the plot of land of the petitioner, which at the time of reconveyance had DAG number 25 K, small a, and presently is assigned DAG number 270, was never during the various settlement processes assigned DAG number 19. He submits that the specific case of the defense authorities is that DAG number 19, a plot of land covered by DAG number 19 belonging reserved for the defense forces, reserved for the respondents, have been under unauthorized occupation of the petitioner. The trace map brought on record along with the said additional affidavit denotes the defense land to be a DAG number 276 and DAG number 429. This court finds that between DAG number 276 and the DAG of the petitioner, there is a PWD road plus other plots having different DAG numbers, and there is no direct access from the defense land covered by DAG number 276 to the land of the petitioner covered by DAG number 270. Further, the defense land covered by DAG number 429, in between the defense land covered by DAG number 429 and the land of the petitioner covered by DAG number 270, there is land covered by DAG number 266, 267. Also, accordingly, Mr. Chaudhary, learned DYSGI, on the next date of listing, shall clarify as to the particulars of the land covered by DAG number 19 and as to whether and as to how the DAG number of the said land had changed from the time when the DAG number assigned to the land of the petitioner as 25 K had over the period of time changed to DAG number 270. Also, a registry to list this matter again on 27/3/2026. On the next date of listing, Mr. Chaudhary shall invariably bring on record the said particulars. Also,
Look, can I take back the set of original one? I'll place it on the next day.
There was, Lucy, in respect of paragraph 5, he has to explain, Lucy. Paragraph 5, something is there, Lucy.
paragraph 5 and the
paragraph
trace
five of the
map. You see the
additional
trace map. Mr. Gogoi, you see the trace map.
I have seen it. I have seen it, Lucy.
So you will have to come and say that we are not concerned with 270, but adjacent to either 276 DAG number land or 426.
Or my lord, present whether 426 or 279 is corresponding to 19. Yeah.
So that's what I said. How we
Yeah,
have
lost,
come?
lost.
One, two, 270 and the two DAG numbers. In between, you find there is a buffer, road, land.
And three DAG.
So only we are concerned whether the defense authorities come up and say that 270 as it stands there is correct and we have no claim there, cannot have a claim there. If it is that, we will clarify that. And if there is any other land other than 270 which the petitioner is occupying, we'll allow you to proceed.
Yes.
But you cannot touch
270.
25 or now 27. There's already an order.
That is the other paragraph 5, something they have bring it. Lordship, we will clarify it.
Please. Only this small
Lordship,
clarification.
Lordship.
Interim order, no.
Yes.
I think my lord, interim order has to be continued.
Interim order was earlier to continue. Till the next date of this.
Deeply.
Apologies.
May I please, the lordship? 8 is a committee association before lordship who is employed by the Oil India, and they are seeking minimum wages, my lords.
Okay.
That's all.
Okay. Only that much.
Only that, my regulation we have.
You said you are an association.
My lords,
How can an association, what are the requirements of an association to file a writ?
it's registered, my lord.
It's registered.
It's registered.
And anybody in the organization can walk up to this court and file a writ petition.
No, my lord, the association is before the
Court. But the association cannot sign. Who has signed?
the secretary, my lord. The
Secretary.
my lords.
Which secretary?
But he is the
I'll tell you. He is the assistant general secretary.
assistant secretary.
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 So under what capacity, under what power and what authority is he signing?
My lords.
What is the authority given to him to sign? Where is the authority? Or where is the statement in the petition or in the affidavit that he is representing the or signing the affidavit on the basis of the authority
Madam,
given to
there's an additional affidavit, page para 1.
para 1. But the affidavit does not say anything.
Assistant Secretary of the Association, as such, I'm fully acquainted with the conversion of the factions. I've been authorized by the members of the Petition Association.
Where?
Paragraph 1 of an additional affidavit, my lords.
Additional affidavit.
Filed on 5/9/16.
No, where is the resolution?
My lord,
Where is the resolution?
resolution, my lords. Registration,
You have to be given a authority.
my lord.
Who has authorized you? If the members have authorized you, there was a meeting, therein a resolution was adopted, and then you did it.
My lord. I find the constitution.
We only want the resolution authorizing.
That I have to seek, my lord.
That
Otherwise,
cannot
my lord,
see in
otherwise,
2000.
lords, I was covered by judgment of 1982, my lords.
What is the nature of engagement of those people there?
Well, something else is said.
What is that else you tell me now?
Well, these people, petitioners, my lords.
No, in your judgment.
No, it is something different. But
What
it
is
says
that?
my denial of minimum wages is violative of Article 23.
Okay, what was the nature of work and what was the nature of engagement in that case?
Well, these cases, this is something different. This is an association, my lord. This was a
Forget
case,
the association. What was the nature of engagement?
my lord, those were nature of
Congrats.
migrant workers, employment of children, like everything was discussed, my lord. Every law. was discussed.
What is the nature of their engagement? They were engaged by somebody. Who engaged them?
No, my lord, it is a it's a kind of umbrella kind of.
Umbrella kind of thing will not do.
Well, kindly have.
Here, you are the appointee under that Village Defense Forces.
Yes,
Act.
yes.
Under that act, whatever is there will flow to you. Where is the requirement of a minimum wage or a regularization?
Regulation, I'm abandoning.
You are
abandoning.
Then the minimum wages thing.
Abandon. Because
Minimum
my lord,
wages thing, because the act, Village Defense Force is a voluntary organization.
I'm a member of a VDP. That's a different issue, man, altogether. But Oil India is using my services. Requisite through the state government.
It's an
Getting
engagement
100
made.
rupees a day, my lords. As of
Not on
today.
that. That is the amount which has been fixed by the
State government. my
state
lord.
government.
So state government is violating its own memorandum, my lords.
It cannot because that organization is nothing but a voluntary organization.
That may be, my lord, but you cannot deny me the minimum wages. Lordship will
Yes,
see.
what do you say, Mr. Chaudhary?
My lord, section 10 of the act, there is a bar to remuneration. After we took the objection vis-a-vis section 10, they or somebody aligning with them filed a petition challenging section 10 before division bench. I withdraw it.
They have withdrawn it.
They have withdrawn it. So as on date, section 10
Section 10
is
will hold if it.
yes,
And their engagement is through the
police
act. No,
through the act.
through the act
Yes.
to you.
We place our requirement before the police. Police in their wisdom picks up.
Yes, Mr. Gogoi.
My lord, they have filed an affidavit, my lord. They've said that whatever rate is fixed by the police, by the state authority, they will pay us, my lord.
That is up to you.
So, my
You
lord,
go
it is for
before
the, I'm not,
police.
it's the paymaster is the Oil India. That's not disputed. But state government has to provide me the minimum pay because they are,
But the oil.
my lord, their
yeah.
own notifications are there of state government, my lord.
Now show me that when the act says that no, section 10 says no remuneration.
I'm not seeking remuneration.
You don't work there.
You give me the minimum kept what is there,
You don't
admissible,
work
my lord.
there. You are not a regularly engaged person.
Well,
Your
they are
members
using
regularly engaged.
they are using our services regularly, my lord, always. Even today, my
My
lord,
lord,
I got a
this-
screenshot. I got
My
my
lord-
lord, 100 rupees a day. They are paying me, still paying me.
Well,
They have 2,000 people under each
our simple
organization, my lord.
case is that, my lord, as and when there are requirements, requirement is perennial. We place the requirement before the state government.
State
State government nominates people, places them under our disposal, and based on the rate fixed by the state, we pay from our revenue.
Who is for the state?
And on the face of Rule 10, my lord, which specifically says that there is bar on remuneration, it's a voluntary service. The idea of voluntary service and minimum wages do not go hand in hand.
Well, voluntary service is a different issue. But can a person survive 100 rupees a day, my lord?
Who asked you to do that voluntary service?
Because all along, my lord, they've been
Mister, what
using our
is
services.
voluntary service?
My lord,
What is voluntary service?
my lord, voluntary service is something which you cannot ask for wages. That's a different
No.
thing, my lord. There has
No.
to be
Voluntary service is something which you on your
I
own
undertake
motion have.
on my motion, my lord. But my lord, I should not be denied the minimum wage.
And you
Honorarium
file
should be
this,
the
file
minimum
this
honorarium, my
thing,
lord.
file this thing without bringing on record the resolution of your
I
members.
cannot say, my lord. It's a 16 matter, my lord. But
15 matter, 60. Before that, you filed one.
my lord.
When this plea was taken, you withdrew.
My lord. I am not the one to take the blame for this, my lord. because this is an old brief, my lord. I had just joined them. I was
Mr.
not,
Gogoi,
my lord.
when you step into the shoes of a counsel of a petitioner,
My lord.
it is immaterial whether you were there from the inception of the case
I don't understand, my lord.
or you have come in at the
Understand.
time when it was in the
My lord.
ventilator.
Now the entire grievance is against the state government, my lord. State government has to clarify whether I am covered under minimum this wages or not.
Yes, Mr. Gogoi. Why are you doing this? Oh, Mr. Sharma Burwa, okay.
100
Mr.
rupees a day,
Burwa,
my lord.
what is this?
Lordship, let me get the privilege of giving a reply to your lordship at 2 p.m. Lordship. Okay.
Or some other day.
Oh,
No,
okay,
my lord.
2 p.m.
Can be taken up today.
You give me the, when he has asked for a privilege, how can I, such nicely put, how can I say no? Take 5 minutes because we have to dictate a series of orders. So take 5 minutes, we'll finish it off. কাম করা Yes, Mr. Abhinav.
Somehow your lordship may be pleased to take up this matter, item 33. The question of ration is involved. For last 2 months, ration could not be Samabhai Samiti because of the status quo order.
33 হলে কোনটো হবো এটা নতুন? What is the case number?
Last 33, last one.
38.
33.
What has happened here?
My lord, here there were 7 elected persons.
7 elected, 6 brought in the no confidence motion against the chairman. Ultimately, chairman was removed. Then I became the chairman. He filed an appeal. The registrar said, as per clause 10(6) of the bylaws, you did not give 1 week clear notice to them. And as such, those resolution of that no confidence was set aside. We approached this honorable court saying that 10(6) is not applicable. Over here, it is that 10(9). When there is a question of requisition comes of the nature of no confidence, it has to be conveyed within 1 week. 10(9). So what this honorable court issued the notice, at the same time, we said we did not hand over the charge. They said the registrar has given the order that earlier resolution is gone. Then the court said, okay, status quo. So with the status quo, what happened, my lord? The operation of the bank account also stopped. And it remained status quo. For last 2 months, ration could not be lifted. And as such, the people, it's because of the festival and all these things.
You are continuing.
I'm there on the
He's
last.
also continuing.
Yes, I'm there.
You are the new one.
I'm the new
old one. You are the old one. Do one thing. If you are a real well-wisher of the people, allow the new one to operate the bank account to that extent. We will clarify that.
I'm the new one.
You are the new one.
Yes.
Allow the old one to continue till the next date status quo.
No.
Because you are so worried, we permit you.
No.
I'm passing the order.
No, I have.
Mr. Abedin will allow the
I can't.
old chairman to continue.
No, I can't.
For the purpose of.
No, I can't allow. But I have a suggestion if your lordship takes it, my lord.
Mm.
During our fight before this honorable court, in the meantime, the people should not suffer that departmental officer may carry on.
Okay. What we do is, he says he is continuing. You say you are.
No, he doesn't say he's continuing.
Okay. Who is there for him? Who is the advocate?
Advocate is Mr. K. Uddin is there. Mr. Roy is.
You P.K. Roy Chaudhary.
Yes.
Get them. After, if they pass the order, after passing of the order, if we have time, we'll consider that. Because 3:15 we are getting up today. Why? Give me a reason. What is left here? What is left here?
There is your.
Nothing is there.
There is your.
What?
Because
2011.
12. My application was of 12.
No, death is 2011.
Yes, that's correct.
After 14 years,
Yes,
do you think we'll have compassion to?
Because the
compassionate
resolution appeared in, we have served the Dusty. He has appeared, his name, some council's name, shown your lordship.
Who?
The name of the council for the respondent number 5.
He is appointed then.
But his application was 2013.
That cannot be. There is no law that it will only be in this sector.
There was vacancy of 2012.
Was there? You missed the bus. You missed the bus.
Let me satisfy your lordship. After
The prayer of Mr. Edas, London Council for the petitioner, registered to list this matter again on
25th, your lordship.
24/3/2026 as a top of the list.
Much obliged, your lordship.
My lord, in respect 23 and 24, may I lordship's kind indulgence to make a prayer for adjournment of the matter for the day, my lord. I have some personal issues today, my lord.
Have you informed the others?
Yes, my lord.
On the prayer of the London Council for the parties, on a prayer made by Mr. R.M. Decca, London Council for the respondent number 6 in review petition number 87/2024 and respondent number 1 in review petition number 88 of 2024, not objected to by the London Council for the review petitioners, registry to list this matter immediately after the ensuing Bihu vacation.
My lord. Deeply obliged.
Lordship, item 9.
Hmm.
Lordship, we have received fresh instructions from our client to withdraw from the matter.
To withdraw the matter or you to withdraw yourself?
No, withdraw the matter, your lordship.
Withdraw the matter. What happened to the Supreme Court case?
Item 9, your lordship. We have, I'm not aware.
Italy Chaudhary.
Italy Chaudhary.
You are there in the case.
I'm not there in the case.
Who is
I'm
there?
appearing on behalf of P. Monte, your lordship.
Anybody, R.B. Gohai?
RB Ghai is not there.
Mr. Monta is not around.
No, he's not. He has some personal inconvenience, your lordship. He could not.
Your
be
name?
present. A. Goswami.
Mr. A. Goswami, learned counsel, appearing on instructions of Mr. P. Monto, learned counsel for the petitioner, submits that the petitioner has instructed not to press the matter any further and accordingly prays that he be permitted to withdraw the same. Prayer accepted, a registry. You are appearing.
Lordship, I'm for respondent number 1, 2, 3, and 4.
Your name?
PJ Das.
Mr. PJ Das, learned counsel, appearing for the respondents number 1, 2, 3, and 4. Does not object to the prayer made by the learned counsel for the petitioner. Accordingly, the petition stands dismissed on withdrawal.
Obliged, Lordship.
We'll come back at 2.
My
Mr.
lord,
Bhuya, got the
no, my lord, just one small, my lord, mentioning, my lord, what has happened in today's series. Item number, earlier it was 30, my lord, WPC 1649. The last item of the series, my lord. Matter relates to, my lord, Tongia settlement, my lord. We are not the encoachers. We have taken a plea that.
Which one?
35.
Item 35.
Okay, we'll exclude that from that.
My lord can exclude this and fix some other day, my lord.
We'll see.
My lord.
35 today.
My lord, item number 30 and 33, my lord. Here, my lord, our stand is that our land belongs to Revenue Village and we have sufficient, my lord, land documents also, my lord. But after receiving, my lord, notice from the committee, we submitted representation along with our personal documents. We were expecting that we will call for personal hearing, but personal hearing was not taken.
You also are, in terms of that Abdul Khalik's decision only, you had approached this court earlier.
Yes, my lord.
Where is the decision? You have gone to the Supreme Court also.
My lord. Here, my lord, I have annexed my earlier orders also.
35, what is the issue?
Item 30.
35.
My lord, 35 is the issue. Is, my lord, we are, my lord, Tongia settlers. Tongia is a, my lord knows, my lord, is a cultivator appointed by the government, my lord. My lord, may kindly turn to page 162, my lord. So, my lord, these are the peoples, my lord, who are being allowed to remain in the forest as a forest workers or cultivators, my lord. By virtue of this Tongia cultivation under the rules, my lord, there is a provision under the rules for, my lord, establishment of this Tongia and forest villages under section.
You don't have residences there.
No, my lord, once the land is allotted, my lord, we are.
Land is allotted only for cultivation purpose.
In that cultivated area, my lord, we are also being allowed to remain as a forest worker.
Where is that? Where is that provision?
No, that provision is expressly, my lord, they have not issued any certificate, my lord. But as we have been allowed to remain there as a cultivator, my lord, by virtue of that, my lord, we are also residing there in, my lord. So, my lord, another 2 petitions are there, my lord. So, this matter can be taken up by my lord on Monday coming, my lord.
On the prayer, 35 would be on the prayer of Mr. A.R. Bhuya, the learned counsel for the petitioner. Registry to list this matter again on 23. 23/6. And madam, your case?
30 and 33.
30 or 33 years. It will be like passing a final order. I could only record Mr. Bhuya's submissions. Your submissions are, I finished it. The Bhuya submission I have recorded. Let us see if we can finalize it today. We'll pass the orders at 2 tomorrow because we'll have to get up at 3:15 today. Yes, madam.
Item 30, my lord.
WPC 1618.
Yes, my lord. In this case, my lord, the opportunity of, my lord, a personal hearing was not given, my lord.
Okay, where is that requirement in the Supreme Court order that a personal hearing is to be given?
That I have not annexed here, my lord.
There is no direction for the.
My lord, no, my lord, representation clause is there, my lord.
You have given a representation.
Yes.
What is the document you have to show that you are the,
Revenue receipts, allotment orders.
where?
Revenue receipts, I have annexed it, my lord, item 33. And here also I have sufficient my revenue.
No, where is it? Just show me.
In item 33 I have.
In item number 30, where you have?
30 I have, I have not annexed, my lord.
That have you produced before the authority?
My lord, they did not get the opportunity, my lord.
No,
They
the
were
notice-
expecting that they would be called for.
Madam,
personal hearing.
that plea would be not
They may
permissible.
be allowed to file additional affidavit. I have, my lord, all the
Okay, how
documents.
long will it take you to file?
Only 1 week, my lord.
Both the cases.
No, here I have annexed, my lord.
Item number 30, on the prayer of Miss S.B. Chaudhary, Learning Council for the petition, registry to list this matter again after a week, enabling her to bring on record an additional affidavit. Okay, 33.
33, my lord. I have annexed revenue receipts, my lord.
Where do I find that?
A series, my lord.
27.
Annexure A series, page 27 to 54. I have annexed one receipt from my lord, 2 receipts like from each of the petitioners, my lord. But there were sufficient numbers of my lord receipts, my lord.
Where is there any order of allotment in your favor?
Allotment is there, my allotment is there, my lord.
Where?
I have not annexed here also.
To file an additional affidavit?
Yes, my lord, in here.
Same prayer. 33. 33 to 33, no? 30 or 33. Okay.
Obliged.
30, 33, 35. 34 is same.
Yes, my lord.
WPC 1649, 1633 2026. WPC 161526 and WPC 161626 is the same.
My lord, my lord.
Huh? But different forest areas.
Different forest.
Have you written that?
My lord,
Just give it to me.
my lord.
Ekta likha. 28, 29. Sorry, WPC 1615 2026. 1616 2026.
My lord, in item number 26, my lord, in 31, WPC 1620, my lord, there were earlier, my lord, order passed by this honorable court for the purpose of giving allotment or considering for the allotment of, my lord, us.
That order is there, that will hold the fill. Here we are only concerned whether you are 7/3/2026. Validity. Okay.
Now, my lord, as this is relevant in item number 31, the earlier writ petitions orders, my lord, I have been informed that those are not being supplied to me, my lord. Can I, my
You
lord?
have not supplied before the committee also.
No, committee also we have supplied, my lord. Committee
It is
also
there. So
we have supplied, my lord.
1620.
My lord. কোনটো আছিলে এইটো জানাত 162089
1620. Where is your representation?
আতাউর রহমান কো দিয়া আতাউর রহমান
I'm sorry, there is nothing here. Page 255. Same thing.
But my lord, we have.
You have it, keep it. We can't help it because we'll only have to be looking into the aspect from the materials already brought on record.
Lord, I can bring it on record, my lord. I can bring it on record.
Everybody is sighing away right now from the order to be passed, my lord.
No, my lord. In
After
other,
so long hearing, my lord, everybody is sighing away.
I think I am the only one who does not have a sixth sense. Others seems to have a sixth sense. I've not declared my order.
Exactly, my lord. But
yes,
one after another.
You want to do it or you want to adjournment?
No, my lord, I will bring that.
Okay.
Because that
On the prayer of Mr. A.R. Bhuiya, item number 1620/2026, registry to list this matter after a week on a date to be fixed by. There is nothing causing prejudice to you, Mr. Goswami. He is taking an adjournment. There is no interim order. So we'll now pass orders in 1615, 1616, and 1616, only two cases.
Item 34 also, my lord.
And 34, yes. 1633.
No, 1649 is adjourned, my lord. This is a Tongia case.
No, 1633 was enough.
Okay, Mr. Bhuya, which are the cases now we are taking up? 1615,
My lord.
1616,
My lord.
and
And my lord, this
1633.
1633 and
Yes.
yes, my lord, these three, my lord.
This thing, Lekha. WPC 1615/2026, WPC 1616/2026, and WPC 1633/26. Belek belek क्यों होना है? But Mr. Learned Counsel for the parties at some length. Hearing remains inconclusive. Registry to list this matter again tomorrow at 2 p.m. Tomorrow 2 p.m. you will get the order. Tomorrow 2 p.m. I'll have the order delivered. But give me that different cases, villages and the forest.
Yes. I have some difficulty.
You need not be here. We
Mr.
have heard.
Gogoi and my entire
Mr. Bhuya also need not be here. I'll
Oui.
pass the orders today, but I won't be able to upload it, so I'm keeping it for tomorrow.
Deeply,
My
deeply.
lord, I'm just for clarification, my lord, if I can caution the parties, my lord. My lord is rejecting the.
I'm rejecting you.
My lord.
Deeply obliged.
Obliged, my lord. Highly obliged.
Section 10, my lord, has undergone an amendment.
Where?
So that part remains, the remuneration. My lord, by my line of defense is,
Now, what is that amendment?
I'm giving you.
That part has been taken away.
No, it's there, still there, it's still there. I'll try to differentiate. It amended in 2024.
Yes.
Yes, my lord, if my lord reads that very lines, my lord, there's a line in this in the organization. My line of argument is this.
You are in the organization.
No, I'm in the organization. That's admitted. That is admitted. My issue is you are using my services for Oil India. Had I been confined to the duties which are assigned by the VDP Act in the VDP Act itself, I'm being used as a VDP agency as being used as an agency.
Mr. Gogoi,
my lord,
one query. When you were engaged as a voluntary village defense organization.
Yes, admitted, my lord.
For that, we in the village only. You're not going beyond the village.
No.
Huh?
No.
One aspect was look into the pipelines. That's all. But this is not a direct engagement made by the Oil India Authority.
Exactly, man.
It's an engagement made through the police.
Policeman.
And otherwise also, if you were just a member of a village defense force, you would also be engaged by the police for the same very work. It is only a specification. Earlier work, you would not have got anything. Now you are getting something. Right? Now you are getting something. Now that something is sufficient or not has to be understood when the work is voluntary in nature. If it was that word was not there, then the Minimum Wages Act would have come in. But now that is excluded.
Well, it is not expressly excluded, my lord. What my line of argument is.
We'll do that with the subject to the appeal and Supreme Court.
My argument is that had I been confined to those activities which the Act says, my lord, enumerates, then I'm not entitled. Now the agency.
What is the Act? The Act says what are the factors?
My lord,
then why did you accept that voluntary? Why did you volunteer to do that?
My lord.
Why did you volunteer to do that? You should have refused. That we will only limit ourselves to this.
Well, since it's one of our duties, my lord, since police
it is
has
a
approached
duty.
us, police has approached us, my lord.
Read it as it may. If you find that this is not in terms of a village work of a discharge to be by a village defense organization personnel, why did you go and do that? Simple.
Once at that point of time, some amount was given. Because 80 rupees initially it was engagement. Now it has been increased to 100
The
rupees.
oil authorities have said that they have done it on their own, on the basis of the recommendation of the.
Yes. Now my grievance is against the state. Because in today's condition, 100 rupees a day.
That we will do one thing, we can give you an opportunity to approach the state.
We have been approaching my lords, Andolans are being carried out, the work, everything is done. Nothing
Yes, who
is,
is
they are
appearing
not paying
for
any
the
heed
state?
to us, my lords. And that about my lord, I had.
Yes, how will you survive on 100? If you're paying something, pay something worthwhile. Whether this is remuneration or pocket expense.
Pocket expense.
Yes.
Mr. Gogoi,
My lord?
let madam find out.
Yes.
Show me that 100 rupees is given to you as remuneration.
I have that. No, not remuneration. It just deposits in the account as 100
How?
rupees a day.
What is the head of that account? What is that
My lord,
payment made for?
It links, my lord. It
You
is
have
linked-
sapani.
My lord.
It is for sapani.
It said reward, my lord, because the
It's not a reward.
word used in the act is reward. There,
The-
Oil India says a reward, my lord.
You have not done any exemplary service.
My lord.
Now, if you do exemplary service, that will flow. Something else will flow.
My lord.
This is just an out-of-pocket expense. In your affidavit, where is it, Mr.? I found it somewhere.
Whether it is under chapter 7 of the rules.
I have the rules, my lord.
Chapter 7 of the rules, village defense parties shall get financial aid from the government as out-of-pocket money.
Expenses.
Excellent.
Mr.
My lord.
We'll give it a closure.
My lord.
We'll give it a closure.
My lord, I have to, my lord will grant me one more chance, my lord. Because my lord, the judgment is my
On
lord.
the
look-
prayer of Mr. D. Gugoi,
My lord.
Learned Counsel for the petitioner raised it to discuss this matter again on Tuesday. No further adjournment shall be granted.
My lord.
So dismissing it on Tuesday. Just give me a copy of that, Mr. Ask your junior to give me a copy of that.
Rules.
Rules, yes. Yes, Mr. Soikia, why are you here?
Matter.
Which one? Eviction?
No, that MLA's matter who is alleged to be a foreigner.
Oh.
I
Is
think
it
one or
there?
two matters later.
That matter.
Vijay Malakar. Yes.
Supply list.
37. So we have filed a affidavit regarding the maintenance.
Raja Gopal Sinha.
Yes, ma'am. Yes, Brajagopal Sinha versus Vijay Malakar. I don't think they will want to still continue. Because today the new list has come.
He's appearing in this case, madam.
Who?
Mr. Kian Sodri, madam.
Give me a date.
So in the
There is no interim directions.
No. There is no interim.
Let it come, madam.
We are rising at 3:15 today.
Just call
But I'll not, we cannot take up because we have kept some matters in above also. I have an order to dictate also.
So this matter may be taken after Bihu vacation, Lordship.
It appears, just.
Let it be there. Let Mr. Well, I got it. Whether this can be argued here. Whether we are the right forum. I'm a bit skeptical about this.
We have filed the affidavit only on the point of maintainability.
Today?
Yesterday we filed it only on the preliminary point of maintainability. Of
What is the ground taken?
Ground taken, there are a lot of other.
Maintainability on the, because of the forum. Election
Yeah,
dispute.
exactly. That is
election dispute.
Yes, they should go for election petition. So they will get an opportunity on, I think, 9th of, or maybe in 3 days time, before 23rd, to raise their objection again.
Against that man. And this is very technical. I'm just going through the, not very, saying that law is not in my hand, but I was reading.
Yes.
Wherever you have to raise such objections, which is permissible to be raised before the finalization of the candidature, has to be raised there. And if not, then it will go before the election tribunal in the form of election petition. Governor can do it for acts which leads to disqualification happening after the person had become a MLA.
That can be done, but in a different circumstance.
That's what. After he has become an MLA, anything he does thereafter, that will then go to the governor. 102, 105, something like that.
Yes.
Yesterday, I was just curiosity, I was reading. Today, it may not be possible.
Just, my lord, I'm
Okay, for your satisfaction.
So my colleagues will be here.
Ah.
Highly obliged.
Because I have to dictate an order. Mr. Singha is waiting for 2 days.
Lordship.
I have to finish that. Yes.
May I please, Lordship?
Yes. He is there from 82.
My lord,
Read it as it may. Provincialized subsequently.
yes.
Then
My lord, date of regularization is the,
rate of regularization, we have already rejected that plea of yours.
my lord, last date lordship was indicated, my lord. He was only proportionate pension, my lord.
No, if it comes from 82,
My lord, he was.
this is the problem with me. If you
Initially,
if you don't stick to my view that I take and give me time to read, I again get something else.
My lord, he was initially appointed as a teacher, my lord.
Be that as it may, under you.
But
Under you.
not against any sanctioned vacant post, my lord.
Show me which panchayat employee was appointed against any some sanctioned post in PRI.
My lord,
None of the cases that I dictated had that characteristic.
my lord, in fact, lordship is very much aware about that. All Assam Gram Panchayat secretary.
Secretaries.
In that case also, from the date of regulation, they were granted, my lord.
But he is not a guy. He's, what is he?
Different.
He was initially he was a teacher, my lord. Thereafter, he was regularized against the LD as LD, my lord.
But he was
not
under that
working
91
against the
He's under that 1999 or 91 that act of provincialization.
1999, 91.
91 provincialization.
But those cases, my lord, those employees were working against sanctioned vacant posts.
No. Show me a decision.
My lord, Fazli Rabbi case is there, my lord.
Fazlal Rabbi, then the decisions that I passed,
Yes.
you had taken in all those cases the stand or rejected the cases saying that from the date you got a scale of pay, you will be entitled to pension, not before that.
Yes.
This court said no. Provincialization, that Fazlal Bibi, Justice Roy's judgment,
Yes.
will go back to the date of their initial appointment.
Yes, Fazli Rabbi case said, my lord, that they were engaged against sanctioned vacant posts, my lord. Only because of that, my lord, that reason, they were granted full pension from the date of initial.
That is not there. Okay, we'll hear you.
Lordship.
Bilaspati Varadi. As prayed for by the Lana Council for the parties, registry to list this matter again on 25.
20.
Yeah.
Obliged. Right.
Lordship may take up, my lord, I don't know, 14 first, my lord.
Who is for 13? Nobody is jumping. Yes, what is your case?
My lord, my case is that, my lord, regarding the word preference, whether preference can be given or not.
At the start of this election process.
Yes, my lord. That is my case, my lord.
Show me any law.
My lord, there are many judgments, my lord. So, if your lordship kindly peruse Annexure 1, page 23. I was appointed as a district fishery officer.
Under a project.
Under a project on contextual basis for 1 year. For 1 year. But I continued there from 2006 to 2015.
Okay, fine. Now come to page 41.
41, my lord. My lord. This is my address, my lord.
Preference will be given to those candidates having experience in execution of supervision of civil works under fishery department. Now show me, this is an experience. This is a preference which has to be given right at this stage of screening.
Unless and until when this preference was given only because of this petition, my lord, only. There are no other candidates. Similarly, they are working, my lord. But they have been out.
Now, what is the meaning of this line? What do you understand by this line? How the preference is to
As
be
per my lord, my interpretation is that preference, they have, though they included the word preference, But how it will be given, that has not been explained here, my lord.
We'll explain that now. You make your submissions, how it is to be given.
Yes, my lord.
You make your submissions.
Yes, my lord. I'll make a submission, my lord.
So that is the only thing we have to decide.
Yes, my lord. That is the only.
Now forget the petition. Now give me the law.
In the affidavit filed by the respondent, my lord, they have come to the affidavit filed by respondent number 3. Here, my lord, they have shown, they have taken a decision after the advertisement was published, whether it is allowed or not. After publication of the advertisement, whether they can change any clause.
Where they have taken, where is that?
The affidavit filed by respondent number 3, my lord, Lordship will find at
Prakash Ranjan Garfulia.
Yes, my lord. Yes, my lord. Form paragraph number 4. 4, they have said that, but the petitioner failed to success in the written case. As such, the names were not considered for viva voce on so and so, so and so, so and so. And now the question comes, my lord, whether the preference has to be given.
That is what
that is the point,
law.
my lord. I have to give a list of decisions, my lord.
Give me one decision that supports your case. That'll do.
My lord.
Mr. Monto, your case is that this is a preference. If 2 persons get the equal mark, then he will score a mark.
Not that.
Then?
Yeah, we law provide. No, here in this case, he is failing the written test, my lord.
No. What is the meaning of this preference?
Yes, that is the law provide. Yes. That is only on viva. That is the rule, my lord. That is the 55, my lord. That is the rule, my lord. Last one, my lord. 50%.
That
is the, my lord, old law. That is that time it is prevail, my lord.
No, here what you have come to page 41.
My lord.
This is different. Preference will be given to those candidates having experience in execution, supervision of civil works under website.
That is department wise experience, my lord, in department wise is different.
But fine, but that is not this. This experience, show me what it is.
Hello. Paragraph 13, my lord. Paragraph number 13. How the preference should be given? Preference should be given, counted at the last point. After my lord, written test, I have to then only, my lord, what I have, my lord, in me, it will come out.
His husband issued. Husband issued. He good.
That is so. Yes, sir.
$80,665.
দুটা আছে 14 টো লৈ আছে চাকৰি নাপায় প্ৰথমটো দুটা আছে দুটা আছে 14 টো লৈ আছে ৰেগুলেশ্যন কোনটো লৈ আছে 14 কি হেৰি কিমান 6448 448 no 6448 448 হয় হয় এইটো আছে এখানে
Yes, what do you want to say from this?
I want to say that
Your main case is for PRs filed for regulation, madam. But department has not yet filed any affidavit, madam. Your lordship kindly see their PRs, main PRs for regulation.
But they have participated in the regulation cannot take place. They have participated here.
Here, yes, they have participated and they failed in the written examination.
That is
That's
my-
why they are not
What
called
is-
for
what
the
is
inter.
this decision?
As per the decision, what I understand, madam, the preference should be counted at the last point, not at the threshold, madam. At the
No,
threshold,
that's
I let it out.
You reach the last point, you get the preference.
I am not allowed to sit in the interview,
Mr.
madam.
SP Das, Learned Counsel for the petitioner. Also heard,
And item number 13 is defined, madam. Item number 13 is for regularization, madam. 13, madam. I filed the RTA before the authority during the pendency of this case. The respondent authority have said that there are 9 numbers of vacancies. If your lordship comes to page 77.
now how can I direct for you? When did you join? 2006.
2006, madam.
Upendas is staring at me. SP Das, Learned Counsel for the petitioner, Mr. TJ Mountain. Assisted Learned Senior Counsel, assisted by Ms. T. Sharma, Learned Counsel appearing for the APSC. Son has appeared for the other respondents. Hearing concluded. Registry to list this matter. Did you announce it?
Not further hearing, one such, madam.
No.
No, one such, for the further hearing, madam.
27.
Further hearing.
Further hearing, madam, one
Okay.
such, madam.
Hearing remains inconclusive. Registry to list this matter again on 30.
Madam, madam.
30 for further hearing.
Further. Keep looking. Obligation. What is it?
Yes.
As per earlier order, my lord, my Learned Senior Counsel had filed a additional affidavit, my lord. Filed order in person, pursuant to the order 29/8/24, my lord. There are 2 questions are involved, my lord. Whether it is permissible on the part of board for the change of service condition of an employee during the period of employee in service or even a post of his retirement, thereby affecting the entitlement, my lord. In view of clause 20B of the Assam Tea Plantation Provision Fund and Pension Fund Scheme, my lord, stipulating that board shall, with the approval of the government, make regulation regarding recruitments, pay and allowances, discipline, superannuation benefit, and other conditions of service of the members of the staff. Can the board unilaterally, without the approval of the government, change those regulations which were made with the approval of the
Show me that
government?
they don't have the jurisdiction, that much only.
My lord.
Show me that they don't have a jurisdiction to do that.
They have filed additional affidavit, my lord. From the affidavit, it appears that there is no government approval, my lord.
Mr. Das, there was no government approval for that.
But today, we have filed an affidavit in additional affidavit, my lord. That we have said that the board of trustees, my lord, is consisting of the member, the officials of the government, my lord.
That board of trustees is under the act, the authority.
Yeah, my lord. That
But approval must be there, my lord. Although the resolution of the board of trustees.
Show me that, which section 20, I suppose. Para 20.
My lord.
What is that? Just show me. You have the scheme annexed here.
Well, already
that-
a copy is served, my lord. Fine, my lord.
only my lord, I'm submitting, my lord, actually, this is the third round of rejection, my lord, in respect of the same subject matter, my lord. In the earlier petition, my lord, that has already been finally settled by this honorable court, my lord. Whereby that I will play before your lordship, my lord. The last part of the.
How long will you take, Mr. Das, to
My
make the argument? You take some time to make the arguments.
Any other date?
Today, because 3:15.
No, that I, my lord.
On the prayer of the Learned Counsel for the parties, when it be convenient to you, Mr. Das?
Next week also, my lord, I prepare.
Next week, Parivar. 40. 31.
Every first week of April, my lord.
First week of Actary. First. As agreed to by the Learned Counsel, let's take in.
Obliged to lord.
My lord, this matter was heard at length.
What has happened, Mr. Tiwari.
Yes.
We'll now do it
So very
afresh.
well. I hope, my lord, in fact, in the record, my list of dates with brief facts are there. If there
You
is
are a
any
promoter.
change-
You are a promoter.
Yes. Yes,
You are
yeah,
a-
promotees. It's just a seniority between direct recruit and the promotees. Even
Where
then,
is the-
lordship may
where is the
kindly.
provision of the rules here.
I'll take my note to that. Lordship may kindly have this copy.
It's the Assam Food and Civil Supplies
Yes.
Service rules.
Yes,
It is holding the field still now.
yes, it is holding the field.
And the rules that you have brought on record,
Rule 32, sub rule 6.
that contains the amendments also.
Yes. Rule 32, sub rule 6. In fact, lordship, copy is not very clear. So I got it typed out. If it is clear, lordship can read it fine. Otherwise, the
Maybe
better,
for,
I've got it typed.
Maybe for another 2 years, this will hold. After that, I don't know.
No, but even
I
then, at least. Typed copy, in fact.
Okay.
32, sub rule 6. The inter se seniority of sub-inspectors of food and civil supplies appointed under sub-rule 2 of Rule 11 as amended shall be fixed over the sub-inspector of food and civil supplies appointed under sub-rule 1 of Rule 11 as amended if promotion and direct recruitment take place in the same year. Now, my lord,
Can you read it once more?
the inter se seniority of sub-inspectors of food and civil supplies appointed under sub-rule 2 of Rule 11 as amended shall be fixed. Now, sub-rule 2, Rule 11, they are promotees. It is by method of promotion. As amended shall be fixed over the sub-inspector of food and civil supplies appointed under sub-rule 1 of Rule 11. Sub-rule 1, Rule 11, direct recruitment. So over, if promotion and direct recruitment take place in the same year, they say, since it is not the same year, you promotees cannot be placed above the direct recruit. That is a simple case.
And
Our argument is, you created a situation which has come to this pass, when by your own inaction and serious lapses and acts of omission and commission, you yourself create a situation wherein you are taking advantage of sub-rule 6, then that advantage you cannot take. That is the argument and that is the whole case.
that much only.
Yes. Now, my lord, another thing, I will show one more thing. Ordinarily, my lord, in the service law, we all know very well, unless and until there is a requirement that year-wise select list is to be prepared, year-wise, if the vacancies are there, whether year-wise, A.R. Banerjee, etc., series of judgments. Now, in this case, Rule 15 may kindly be seen for a moment. Because I should clarify that rules are not explicitly, it doesn't say so, but by necessary implication, it would come to that. Where it is, Rule 15. This, my lord, will find, in fact, in the written argument is very clear. The type of the copy is good. Where it is? The written argument given by the state in this case. The rules are there. I'll just place it. Where it is? Yes. No, there is a better copy of the rule in the written argument of the state. The Rule 15 may kindly be seen there. What it says. Whether my lord has got it. Rule 15 of the rules.
That selection committee and review.
Yes. So it is not explicit, but by necessary implication, I would show that.
But Mr. Tiwari, what about the purport of Rule 13(3)?
I'll come to that, my lord. Kindly, Rule 15 may also kindly be seen. The selection committee shall meet once a year, and review the select list every year. Now, my lord, question of reviewing arises when there is a select list. When you do not, yes, then what do you do? So, by necessary implication. Then now Rule 13 I come
for the private respondents?
My lord, private respondents, yes, Now, my lord, rule 13, my lord is referring to sub-rule 3.
Yes.
I read this. The appointing authority may from time to time for the purpose of recruitment to the service under sub-rule 2 of rule 11, that is direct recruitment, call upon the recommending authority to submit recommendation in respect of eligible persons together with the character rolls and other connected papers as may be required. No, is by promotion. Character rolls
Because
and
why
other
I say so,
as may be required. The appointing
rule
authority.
11,
Rule
11(2)
Yes.
Says 25% of the vacancies.
Yes.
Yes. So and so shall be filled up from the select list prepared for this purpose under sub-rule 2 of rule 13. From amongst the ministers who are outstanding ability, so and so, so and so, so and so. Now, 13(2) has to be read with 13(3) following.
Yes.
So 13(3), where do you get it that the year-wise the recruitment has to take place? Like we have in other rules, before the end of the each year, the next available vacancies would be.
I get it, my lord, by virtue of necessary implication by reading rule 15. Because the very
Rule
mandate of
15
the
again, rule 15 again, the contrary argument also can be that once you have done a selection, that's the end of the matter. You can review it every year.
My lord, selection.
Because this does not say selection committee shall meet once a year and review the select list every year.
My lord, then I ask myself a question. Records do not indicate even that review was also not done at any point of time, year after year, year after year,
Then,
6 years.
Then the thing would be 13(3). Whether the authority wanted that names to be recommended, they wanted the selection committee to recommend.
The sequence of events clearly indicate that the exercise of making promotion was undertaken much earlier. My lord will see the sequence of events. That is why the list of dates.
Megha Chandra.
That is why, my lord, that is how it will come into play. Because you started much earlier, your own election.
That says that the process may start up anytime. Vacancy may be, now the law is vacancy may be of any year, but you get your seniority from the date you are born in the cadre.
You know, Megha Chandra is in a different situation altogether. And that is also now overruled, my lord, by another judgment.
Okay.
That again, another judgment has come. That situation is entirely different. Over here, my lord, we are into the very interpretation and the scope of the fixation of interest and seniority between direct route and the promotee. Now that it says that if it is in the same year, there is
no dispute.
Well, now, my lord, if I can demonstrate by the sequence of events that there were serious lapses on the part of the state, not only in undertaking the process, but also, my lord, in completing the process within a given time period. They kept on delaying it. The DPC was called for. The DPC was constituted. Again, the meeting of the DPC doesn't take place. I have shown the entire sequence of events. If there are lapses on the part of the state.
Recruits came in the month of May or June 2000.
Lordship, may kindly have a look, my lord.
And the promotees came in 2014.
Yes. In the case of, my lord, direct recruit,
2000.
The select list for direct recruit was published in 22nd of May 2012. The select list was published. And the order was issued on 19th of June 2012. 2012. Now, so far as the DPC was concerned, the process of promotion was initiated, my lord, way back in May 2011. May 2011, and the DPC was already, my lord, constituted on 20th January 2012. In January 2012, they constituted the DPC. Thereafter, they don't hold the meeting for one reason or the other. They keep on deferring it.
Okay.
Annexure 3, page 46 and 47.
26/12/2012, the DPC was held.
Yes, finally.
And the recommendation was given.
After a gap of 5 years. After a gap of 5 years, the DPCs ultimately was held on 26/12/2012.
Recommendations made.
Yes.
But the final approval took time.
Yes, even that also took time. So at every stage, my lord, there are lapses. So therein, my lord, I am placing that proposition of that Supreme Court judgment, my lord, in Kerala case. That is Prem Chandran versus State of Kerala. In fact, my lord, last night I had an occasion to look into the written notes also. I found lots of errors there. Lots of typographical error, repetition. So I made lots of corrections. So my lord may have a better copy. So arguments I have made, my lord, P.N. Ramchandran, and there are other cases also of our own High Court taking the similar view. Because finally, the state respondents cannot take advantage of their own wrong. That is my own simple case. If judgments, my lord, I had given earlier, if the copies are not there, I'm having extra copies with me.
Don't. Okay. What is the justification for the delay?
There's no justification.
Even after holding the
There's no justification.
DPC in 2012?
My lord,
Because if that had come in also.
they have
in
taken one
2012
approach. They have taken one approach. Finally, the promotions are not in the, you didn't get the higher post in the same year. So there is no question of you being placed above the rank group.
They had held the DPC in 2012. That's the only DPC. 2012.
Prior to that, 2006.
Okay, that. But in 2012 is now the
Yes.
determining year.
Yes.
In 2012, there was a DPC. But they had not finalized that DPC in 2012. They finalized it in 2014. If it was finalized in 2012,
even then,
this grievance would not have been.
Yes.
It's normally the reverse situations. The direct recruits who get delayed in comparison to the promotees. Now it's the promotees.
That's it.
The first case I think I have got where the promotees are getting.
Yes.
Normally the direct recruits who are kept away so that the departmental candidates can be sent ahead.
That's it. Now, my lord, may I show the seniority list also, the final seniority list?
Mr. Borua, once you got this 26/12/2012 recommendation of the DPC, how did you process the matter thereafter?
Lordship, what has happened, Lordship? Although, Lordship, the thing is that, Lordship, in 2006, the vacancy arose, and in 2012, the vacancy arose, Lordship. These promotees of 2012 and direct recruitments are also of 2012. The only delay, the direct recruitments, Lordship, they got appointment in 2013. The specific instruction against that, Lordship, what Lordship has just now suggested, is that there were some writ petitions pending, the orders. We have the instruction, Lordship, to comply with that order of those orders, Lordship, of the writ petitions. The delay
Petition pertaining to the direct recruitment or the promotees?
Direct recruitment, Lordship.
Then how can you? Because you have a earmarked the quotas, 25/75.
Yes.
So any decision of this court for direct recruitment will be against that 75%, not against the 25%. But why did you stop them?
Basically, that is the Lordship, that defense they had, the defense the department has taken, Lordship.
No, that's what I want to know.
No, 75% and 25%.
So you show me your instructions, what
Yes,
your
Lord.
instructions are.
Yes, Lordship.
Mr. Tiwari, in the that exercise, direct recruitment exercise, there were in total 145 direct recruits, 130 were appointed. They were not appointed in one batch. They were appointed in staggered batches. You came in 2013. Now, in the direct recruits who were appointed in 2013, are you placed even below them?
Yes, my lord. That's why I wanted to show the seniority list. The seniority list, page 130, the final seniority list of the paper book. My lord, may kindly have a look, page 130.
Yes.
130, my lord, in fact, from serial number 3, Abul Kalam Azad, from serial number 3 to serial number 119, 119, because finally all of them did not join. So 3 to 119 are all direct recruit. And we begin from serial number 120. 120 to 130 are promotees. From 3 to 119.
2012.
Yes, 3 to 119.
And 120, Joinal Abedin and all, same.
These
are promotees.
These are promotees, my lord. We start from 120. 120. Where is the 120? Yes. The petitioners, my lord, will find our petitioners are 120, 121, 120, 120 to 125, 129 and 130. Out of which one is dead. 125 is dead. One Mr. Rahman, Muzammur Rahman. He died during the pendency of this case. So 120, 120 to 124 are before the lordship. Then 129, 130 is before the lordship.
120 is there.
Yes.
That is
120, Zainal Abidin is there. So they're all just at the bottom. And my lord, what we have done is, from serial number 3 to serial number 10, we have made them parties. The very top.
Representative.
Taking cue, yes, Pramod Verma's line approach we have taken instead of making all of them parties. So that is it. So, my lord, we are seeking our placement just above Abul Kalam Azad at serial number 3. That is all.
That's the most easiest thing to do.
The only, my lord, I would urge my lord to consider subject to if my lord.
After you were appointed in 2013, when was the first time the select list was published?
After we were appointed, the first time select list was published. I'll just give the select list. My lord is referring to the recruit or the promotees.
No, select list. Oh, sorry. Seniority list.
The seniority list. The seniority list, my lord, after our appointment, that is DPC is held 2012. The seniority list finally, the final seniority list, because the provisional when it came out, we challenged it. And the final gradation list of sub-inspector was published on 28th June 2019. Annexure 14, page 129 to 137. That is impugned. 28th of June 2019.
Final.
Yes. The provisional was challenged. We submitted representation. The order was passed, dismissing it on 30th January 2019. serial number 22 in the list of dates.
And which is the decision you want to now rely upon?
In fact, I have all referred those. I have referred to those decisions in the write-up I have given to your lordship. Citations are given, but even then, I can submit a copy.
No, I have it. That's why I just wanted to.
P.N. Ramchandran, lordship has got it. Then Tomba Singh possibly my lord doesn't have.
Tomba Singh I have.
Tomba Singh, M.V. Muralidharan, Justice Muralidharan from Imphal bench. That my lord is having. Very well. Then Tomba Singh, and thereafter Oinam Brajchandra Singh, also my lord is having. And then Kusheshwar Prasad Singh.
Kusheshwar, yes.
Kusheshwar, the relevant paragraph, paragraph 16. 1(6). That is on a principle, my lord, namely that they can't take advantage of their own wrong to seek a favorable interpretation of law.
Then P.N. Premachandra.
Yes, Premchandra. That's these two Supreme Court judgments.
Yes. Any further?
I'm not in that much.
Who is appearing for the respondents?
Private respondents, Mr. Frederick.
4, 5, and 8.
Make your submissions. Pramod Verma, you have relied only for that.
Only for that purpose. Only for that purpose. Lordship knows the principle, so I need not even. That's the advantage sometimes, my lord, we have when the Honorable Court knows the principles.
Oh. But Mr. Tiwari,
My lord.
all said and done. Now, what is your specific averment in the writ petition about the delay caused by the authorities?
I have explained my entire
Your
case is
written argument-
inaction and lapses.
Written argument, it's fine, but in the writ petition.
There also, my lord, I have spoken of inaction and the lapses by demonstrating the events one after another, how it happened. That is the case I have projected. Inaction and the lapses. That is the whole case.
Okay. Yes, Mr.
My lord, may I?
Please.
My lord, may kindly come to page paragraph 17, madam.
Of your writ petition.
Of the writ petition of my senior friend, my lord. That the meeting of the selection committee was finally held on 26/12.
Mr. Ashtama,
my lord.
we may not be able to complete because I'll have to rise in 5 minutes. We'll keep it. Kitya Pari. 7-4. We're keeping it on 7.
My lord. If I may take-
Heard Mr. P.K. Tiwari, Learned Counsel for the petition. Mr. P.K. Tiwari has made his
Can it
submission.
be a week earlier because from 7, whole week will not be here.
Okay. Mr. Tiwari has made his, P.K. Tiwari, Learned Senior Counsel, had made his submissions in the matter. Mr. M. Sharma is in the midst of its submissions. However, due to paucity of time today, the matter be listed again on, I thought data would be at 6.
So can it be on second?
Second, too much. This 2 weeks we are full.
For the whole week from 6 to 10 will be in the Itanagar bench, your lordship.
Okay. Do you take it here? 2.
My lord had raised a query about the delay that might have occasion from the other side.
No, not the delay. I wanted to know why after the promotions were recommended
My
in
lord,
2012,
Yes.
it took a year
Yes,
for the authorities to.
Almost 5 months. That concurrence was granted by the Personal B Department and WPT, who are not parties here, my lord.
See, that's not the stand taken by Mr. Burua. He said that
Yes.
because of hydro orders pertaining to the direct recruitment
My lord.
segment,
Yeah,
the promotees were stopped. If that be so, then we'll have to come in. Otherwise, you demonstrate.
My lord.
Mr. Chaudhary. Oh, no. I missed out that there was an important matter somehow with that eviction matters, I got swayed away today.
My lord, this is very interesting.
I know, I've read it. And
My lord,
thanks to you all.
I can give one judgment, my lord. My lordships may kindly take note of. Oh, okay. My lord, 1999 4 SCC 526. For the facts, para 1 to 4, and otherwise, my lord, para 22 30. Now, the Supreme Court has said, my lord, if the case falls under 190, 191 and 193, then 226 lies.
Because it will be
The
governed.
example given by Supreme Court is, consider the case where the person elected is not a citizen of India. Would the court allow a foreign citizen to sit and vote in assembly and not exercise jurisdiction under Article 226?
There was an there was an example
Yes.
in Assam only.
Yes. Well, that 1950 judgment, that was in a slightly different context. Told us that Saka ki naam se-
1950 has been taken care of here.
Yes, in details. Saka
I did not
Venkatrao.
get this yesterday. I was making a small inquiry because these are topics which are new to me.
Yes.
So I was trying to
In fact,
understand
these
the
are new to us also, my
I
lord.
was
Very
trying to
interesting.
understand. So I was just going through. Okay.
Any date
As agreed to by the learned council for the parties, registry to list this matter again on. Who doesn't know?
My lord, we have filed one IA because we filed.
Mr. Chaudhary, I'm sorry. What has happened is everybody says fix. I have started fixing. Now she says that this week and the next week, totally chock-a-block full. Because I'll fix the matter, you'll have to keep on waiting. Means, what to do?
And
Let it be on 31st, sound, yeah, 31st.
Oh, 31st.
31/3,
Yes.
2026. Next month onwards, I'll be a bit more spaced up. Otherwise, it affects my disposal rate also. Means I can't. Because it will be very difficult to cope up otherwise.
Writing judgment is a tough job.
No.
It's a tough job. And no, question is you have to devote a lot of time.
Mother has sent something.
My lord, in
Mother has sent something.
my lord, in
Given a item to.
Item 8.
Yeah, sub-district, yeah.
Thursday.
Sub-district.
my lord, item 30.
Wait, what?
My lord, item 32 in the morning for the timing it was made, my lord. It's an eviction matter in Yadipatta land.
Monday.
It can
That house has been demolished.
No, my lord. Here, my lord.
Road.
No, my lord. It is the matter regarding acquisition of our agricultural land without following due process. And now,
Due to given item number given?
newly 32, my lord. That can be tomorrow, my lord.
Tomorrow it's not possible.
Because now, my lord, our land is being going to be filled up, my lord. If it is filled up, my lord, it is agricultural land. It will be, its character will be changed, my lord. That is the problem, my lord, only.
Your Patalan.
Patalan, my lord.
2000.
32, my lord. It was already started, my lord, to filling up the whole area, my lord.
Somebody, as prayed for by the learned council for the parties registry to list this matter again tomorrow. That is so.
Highly obliged, my lord.
May I please your lordship? May I please your lordship? Lordship, I have a.
Yes.
Lordship, I have a prayer with regard to item number 25, Lordship. This top of the list, can it be fixed on 31st of March? Because every day, because Lordship, on Tuesday and next Thursday, it will be coming. I'm already having 6 to 7 hearing matters fixed. So
Only.
No, for me, it is.
Only.
So, can it be on?
That is how you develop. I think you should have 2 more.
No.
When do you have 6 matters?
No,
On which date?
on Tuesday and
Tuesday log ID.
You're not on no. You're not kindly may on 31st. Can it be 31st?
7/4.
7/4. Oh, Lordship.
Yes, Mr.
Bless.
Item 38 regarding that.
Who is the Mr. You are the new one or the old one?
No, I'm the old one.
You continue, Mr. Abedin, because of the say. This is how you should be. He's so worried about the people.
My lord, if your lordship has to pass any effective order, first the writ petition has to be maintainable. My lord, your lordship will find the impugn order that has been challenged. All the board of directors were present and their names are there. They have not made them a party also and they have obtained a
Now,
status
how
quo.
do you resolve this issue?
Well, let's any go.
I am the secretary, Miller. You two, they are like dispute. The Malata, I am facing trouble of lifting the Malata PGS items and then Malata not to pay salary to the Malata.
So in such a situation, what to do?
Government employee can.
Government employee.
As agreed to by the Learning Council for the parties, registered to list this matter again on 23. We'll
Not
pass the order.
24, 24.
Why?
23rd, I will be out of station.
24. We'll pass the order.
No,
And
my
we'll consider the matter on that.
lord, only one thing. If your lordship, all the parties have agreed, my lord, let the government officer in the meantime continue. Your lordship may direct the ARCS Hujai to arrange.
Then the order has to be modified because that was a status quo order. That has
You're
to
not agreeing.
My lord, because that order has to be modified.
No, we'll do that if both sides agree. What is that?
Yes.
You're there, Mr. Roy Chaudhary, Mr. Abedin. You're not there because of, for your interest, your interest of the members of the cooperative society.
My lord, because
if they are suffering, if this order can.
they're suffering because of whom? Well,
I agree, my lord.
Because he has come with
No.
petition.
It's not
And
because
my
of
lord,
me.
I am the chairman.
My lord, out of 7, 6 is against
No,
me.
my lord. That
Kali
is,
Rakha. Kali. Tomorrow we'll say.
My lord, tomorrow at what time?
Oh, to the Eid.
No, if your lordship.
let it be on
No.
24th.
Only thing, my lord, what I'm saying is my order, status quo. I give up. Honestly speaking, I give up. Let the government
Or
officer.
can we write that because of the, then if we give status quo up, he'll continue.
No. What I'm saying, during this period, let the ARCS.
That he will have.
My lord, because because my order was no confidence was set aside with the register and I was put in.
bank
Now he
account is
comes
in
and
my
obtains a
name.
status quo order, that too after 10-15
I
days.
got the bank
As
account
agreed
is in.
to by the Learning Council for the parties, registered to list this matter on 24/2/2026. An endeavor would be made to dispose of the matter on that day.
My lord, oblige.
My lord, at 2 o'clock, let it be at
2 o'clock. 2
At
p.m.
2 o'clock.
2 p.m.
24th.
24th.
Okay.
24.
96, maybe second week of April.
36, as agreed to by the Learning Council for the parties, registered to list this matter again in the second week on 7.
Lordship, in this case, we may be allowed to file our counter to the reply.
The parties are at liberty to complete their pleadings before the next date of listing.
Obliged.
Mr. Sinha, I'm sorry. Close. Dispose the idea. But Mr. Sinha, you'll have to bear with me till Tuesday. Before that, I can't give you the order.
My lord.